Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you are not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. The Commission would like to recognize today that we have a new commissioner who has joined Sue Palmer to my left here. So we gladly welcome her to the Commission. Before the meeting, Mr. Fields circulated last month's meeting minutes from December. Has the Commission had an opportunity to review those draft minutes? Is there a motion regarding approval?
Motion to approve the minutes from December 13th, 2018. I'll second.
All those in favor?
Aye.
Motion passes. We have a number of public hearings today. We're going to try to go through those as efficiently as possible given the time allotted. The first public hearing involves applications for taxi cab certificates of public convenience and necessity. It's our annual meeting. No applications were filed, I've been told by Mr. Fields.
I was going to say there were no applications. I think it's appropriate to actually call the meeting, to call the hearing, close the hearing, because there's nothing to consider.
All right. So we will officially open the public hearing regarding applications for taxi cab certificates. Not having received any requests to speak submitted to Mr. Fields, we'll close the public hearing. And not having received any applications, we'll move on to the next item on our agenda. We have another public hearing. We've been asked to review the proposed ordinance changes to the Metropolitan Code of Laws, Section 6.81. Mr. Fields.
Section 6.81 involves booting services. There were several changes that we were suggesting. And again, these are suggestions to the Commission, who would in turn deal with them as either approving them, changing them, rejecting them, and then whatever, if you have anything, then we would suggest it to the Metro Council, then they would have the ability to do what they would have with it. Much of it is housekeeping. There are probably a couple of areas that as we go through, I think the industry is probably at least a couple of them that may want to go through, but there are substantive changes, but for the most part, they're dealing with issues that have come up since the last time we visited the issue.
You got a recommendation, Mr. Fields?
Well, I think most of them are in good condition. There is a continuing issue, and again, I'm sure the industry would talk about it. For instance, Inspector Morris and I were speaking before the meeting. One of the issues continues to be problems with parking lots in town that have multiple ways to get in and get out. The language that has been suggested, and again, it may not have been as clear as I was hoping it might be, just because I'm not sure I'm clear, is that we have an intended entrance, because in fact we have some lots downtown where they do active booting that you can actually drive from lot to lot without leaving a lot. In other words, just basically pass from lot off the street. And when that happens, it's almost impossible to require a sign in the middle of a parking lot to say, hey, you're driving into a lot that you can be booted on. So then when they're booted, they call us and say, hey, so, we've had violations. So there are those kind of issues that continue to be a challenge for us, that's for sure. But I do think there's representatives present.
At this point, we will open the public hearing for comment. Mr. Fields, I did not receive any requests to speak ahead of time. Is there anyone in the audience that wants to speak on the proposed new booting ordinance?
I'm assuming bad weather. A couple were coming from out of town, so it may be that they're out on an interstate somewhere. But they were certainly shared, as we always do. We circulated with the industry.
At this point, we will close the public hearing on the reviews proposed ordinance changes to Metropolitan Code of Law, Section 6.81, and open the matter up for deliberation by the commission.
So what we're being asked to do is make a recommendation either for or against this to the Metro Council, correct?
Correct.
And that'd be done by motion?
Yes.
All right. Mr. Fields, you characterized some of it as housekeeping measures and that there's still some outstanding issues. Is it your recommendation for us to recommend Chapter 6.81 as revised to the Metro Council?
I think it would be appropriate. Again, I think there may be just a little touch of staff tweaking that I'd ask permission to be able to do, again, specifically on the parking lot, because as I continue to read it, every time you continue to think about things. For instance, if we need to add additional signs to a park, right now it just requires signs at an entrance. But if there is a situation where we need to have additional signs, having the ability to, basically adding language that says, in addition, Transportation License Commission staff may require additional signage to fully inform the public of the booting restrictions or the parking restrictions.
Do you know which section that is under 6.81?
It is 6.81180A.
180A.
And it starts with no boot shall be placed on a vehicle parked on private property. It's at the top starts at the top of the page, but I don't have a page number, so.
Okay.
It's on top of page 3 that was
Be
sent to
page
you.
3. Okay.
Again,
Section 11 then.
It's a very it's just challenging for us.
All right. Thank you.
And as the other ordinances have done, and again, as you well know, I'm certainly not a kingdom builder or a rule collector, but it does add additional authority for the director to be able to take more immediate action if need be, if there are issues that arise that are of an emergency manner.
So you're asking for us to give you more authority?
I really want more. I really do. Actually, it brings it more in line with all the other ordinances. One of the things we're trying to do, and you'll see that in the next one as well, is where it's possible and where it's appropriate is let the ordinances mirror each other in terms of driver standards, director authority, staff authority, those things that have made sense before. We think they continue to make sense.
And I take it you've had some discussions with some of the companies that do booting?
They've made a call or two.
Okay.
They've not had as much contact with the commission as others have in terms of, so we don't have a lot of information that's come to the commission in other hearings as opposed to the next ordinance that has had a lot of information come in front of the commission. The booting has not. And some of this is staff changes as well.
And I understand one of the changes is the increase in the maximum booting fee.
Yes, sir. The maximum booting fee at the present time is $50. We're suggesting that it probably should go to $75. It continues to be. This is booting is typically in lieu of towing. The least a non-consent towing bill could be is $145. So it still ranges about half if a car is booted in a parking lot versus towed out of a parking lot. It's still about half. If it also goes to the parking lot and stays more than 2 hours, you have an additional storage fee of $35 added on top. So you could have $180 tow. So this is still nobody wants to be towed or booted, but the reality is this is activity on private property, and the owners have authority over their own property.
When was the last time the maximum fee was changed? Do you know?
It's been $50. Oh gosh, I believe it's been $50 till it started. I'm going to turn around to staff. It's remained $50. Yeah, I believe it's never been changed. Booting was first started in 2010 or 11. So I don't think there's been an increase since.
Are there other fees that get tacked on besides the booting fee?
Well, the only fee that would be is the parking fee or penalty that they are allowed under state law to charge a parking fee and to collect their parking fee, and they can also penalize, but they can only charge what we allow on the actual removal of the boot. But parking fees, sometimes they basically double them. So if it was a $25 fee, they may charge $50 for the parking fee, and then presently $50 for the boot removal. We are requiring to be there within. Once they're there, they have to have the boot off in 15 minutes. They still have. We're working. One of the issues we have is making sure that people, the vehicles are identifiable. We do have issues where people will work without a sign on the side of the vehicle. It makes it very specific what the sign is, and that it has to be on there, as well as identification on the. At this point, they're going to have. They must wear a uniform that contains the name and the logo of the booting company, and says which side has to be even, or jackets. So we just want to make sure that people aren't frightened or concerned about who's providing the booting service.
Is there a section in here that allows them to add on a penalty in addition to the parking fee?
No, that again, it's my understanding that remains in state law. That the parking fees themselves are outside our authority, so they basically charge whatever fee they feel like it's their property, so they can charge whatever parking fee is out there.
How was the $75 derived to be the proposed new maximum fee?
It basically was more of a step than anything else. The company, I wish they were here. They did the companies did some analysis and looked at their expenses compared to where it was and where it is, I think. But it seemed reasonable based on a 7 or 8 year non-increase in terms of to go from 50 to 75, and that it remained about half of what a tow would be. But if the commission, would reduce it, then certainly the commission can make that suggestion today. Yeah. Ms. Ladd reminded me that one of the pieces of evidence that was sent in to us as we started this process was that there were that compared to other cities of our size, we were much lower in some cases for booting fees. We're also much lower in some of the record fees as well, I suspect.
Are these fees collected and passed on to the city in some form or fashion, or
No.
it's just collected
The
by
only
the
fees
company?
we collect is the company licensing fee. We do have a member of the, we do have a representative here from Nashville Booting, and there's a comparison, who apparently has appeared from Atlanta. Would you like to hear from him?
If you'd like to speak, you're more than welcome.
Chip, would
we'll
you-
reopen the public hearing.
Be happy to answer any questions that you may have, sir.
Could you introduce yourself, please?
Yeah, my name is Chip Schmelk. I'm the owner of a company called Nashville Booting.
Where are you at?
I'm sorry, sir.
Where's your company located?
We office over on Division Street.
They had asked the question just now about how the 50 was recommended to go to 75, and basically you just shared with us what that number is. For instance, in Chicago it's 100, Dallas 100, Denver 100, Houston is $342.08. Now that's an interesting fee. 75 in Atlanta, 50 in New Orleans, 75 in Washington, D.C.
So those are the right column is under municipal immobilizations. That's when the city itself boots. Could be for past due tickets owed to the city. Usually the protocol for when municipalities immobilize vehicles is they have at least one outstanding ticket, so they want to collect their fees, their outstanding tickets as well as the fee. The middle column is private property. That's what, if booting is regulated in a certain area, that's what that particular municipality has limited the maximum booting fee to be.
Do your vehicles that respond to removing a boot have decals indicating the company?
Yes, sir.
All right. And your employees all wear uniforms?
Yes, sir. Yes, sir. One addition
Have you had an opportunity to review the revisions to this particular ordinance that we're considering today?
Yes, sir.
Any input?
One of the additions that I liked about specifically about the identification on the vehicles, we're going to add a phone number to it as well, require the phone number for the company as well.
Okay.
I also kind of put some input into having some identification for the employees by having on the exterior, whether it be a jacket or a shirt in the summertime, that the company name or logo is embroidered on the shirt so they're identifiable as well.
Otherwise, you pretty much agree with the revisions to this ordinance?
Yes, sir.
Thank you.
Any other questions? Thank you, Mr. Smelt.
Yes.
I'm just curious about this suspension, section 16. Is that a change to 60 days? Is that a change?
I'm sorry, section 15.
16?
About the maximum violation for the first would be 60 days. The maximum fine for the violation could be up to $1,000.
Yeah.
If the question is why,
Is that an amendment, or what was it before?
I think what we've done is we've added a section.
Okay,
So that's not an amendment. It doesn't exist today. We've added that new section and the following language.
perfect. Okay.
And it's consistent with the other sections.
Mhm.
It's a consistency with the other
Mhm.
sections.
It basically follows the other sections of our laws that we're responsible for.
Discussion there?
Yeah, we are. Just to formally notice here, we will now reclose the public hearing and reopen back for discussion by the commission.
I don't see any reason not to pass it, to make the recommendation to the council to make these revisions that have been suggested to us. At least the one representative from the industry is in favor of it. Mr. Fields says it cleans up a lot of loose ends and seems to also set out some very specific standards and puts us still below the average for private property booting fees, which averaged out at $90, and we're at 75. So. Not yet.
Do we need to amend the language with you regarding the signs?
If you wanted to, again, in situation where we believe that it made sense to add an additional sign, I think, again, simple language saying TLC staff may require additional signs as necessary, or require additional signs. Just, again, it's not I mean, most are straightforward. Some are a little confusing, and the companies have, for the most part, there's still a lot or two that's still a great challenge, but it just protects us going forward to be able to deal with that.
Because I notice it does require TLC staff within 7 days to go out and put a decal on saying they've inspected
Yep.
it and it meets with
Yep.
compliance. So you would say, after TLC has inspected it, if they deem that additional signs are necessary, they shall have the authority to order it.
That'd be appropriate. And what that also does is make sure that that lots are inspected prior to going into service.
What about also some consideration that if you go out there and inspect it and you think the sign that's installed needs to be put in a different spot for more notice to the public? Do you have the authority to do that, or
Well,
do you see that ever happening?
Not if you had the other language, because again, it has to be at the ingress.
All right.
So, and if we have the authority for additional signs, if there is some odd situation where there's two ways in, typically what's going to happen, the company's going to put them both. If there's two ways in, they're going to put signs at both locations. Is generally what happens. It's when it's the odd one where it really is challenging to try to figure a way. How do we, especially when they're entering off of alleys? Y'all have experienced that in this commission. In fact, year before last, you had that issue over off of Eastland Avenue with one that you could actually enter three ways. And one was clearly a private alley that had no street access theoretically, but you could sure get through that way. So that was corrected with an additional sign, I think.
All right, just for discussion purposes, I was thinking, after TLC staff inspects, if additional signs are needed, the TLC director is authorized to order placement of additional signs before booting's permitted. I'm open to how to rephrase that if necessary.
Metro Legal simplified in a way.
Okay.
The TLC staff may, I'm not going to say dictate, the TLC staff may, if necessary, require additional signage for clarification.
Do you want it to be a staff or a director, though? I hate to put that burden on the staff.
I'd love another burden, so we could certainly make TLC director. Normally what would happen is the inspector would inspect,
Yeah.
I'd see a picture, or if necessary, go and look at it. So
I would be more comfortable if it came to you and you said, or whoever the director is,
Sure.
came to
Yeah.
director from a staff person and said, here's what I recommend.
yes, sir, we want to do it.
All right.
Yeah, I think that's a good recommendation because I think it's very important that anyone driving into a private lot, they need to be certainly aware, that it's a paid lot and you need to, go to the machine or whatever.
What's the language you recommended?
I have the TLC director may, if necessary, require additional signage for clarification.
How about additional signage for notifications?
For notification instead of I think that achieves it.
Is that what you said?
Mm-hmm.
Is that what you said?
Mm-hmm.
You just didn't like dictate.
Ready for a motion?
Actually, Mr. Smelt, I did have one more question regarding the fees. Are there other cities of comparable size that are still charging the $50?
Not that I'm aware of, sir, no. We just did a quick
90.
search a few weeks ago because we operate in Atlanta and Miami. So we just kind of took those, that's kind of our home base is Atlanta. So we just kind of looked up some similar sized cities. So that was the information that we had found. So.
Would anyone like to make a motion regarding the proposed ordinance to the council?
I'd make a motion that we recommend to the council adoption of the revisions in chapter 6.81 with the condition with the additional language in section 11 that the TLC director may, if necessary, require additional signature or signage for notification.
Second.
All those in favor?
Aye.
Motion passes. Next, we have another public hearing regarding a proposed ordinance change to Metropolitan Code of Law, Section 12.54, regarding horse-drawn carriages. Mr. Fields?
This is a little more complicated just because it is a little bit longer. It has not been, this particular ordinance for the most part has not been revised or changed since 2002 when that we put it together and actually began the regulation of horse and carriages. A great deal of it actually brings it in line with the other ordinances. For instance, owner applications, driver applications, just basic requirements that brings them in line with the others. Some are very specific to this ordinance. It also creates a hearing process that the executive director of the commission may use to deal with complaints. So we have talked about that and brought it. Most of the things that are actually in here, other than what I would deem housekeeping, have been issues that have come in front of the commission over the last 2 or 3 years. Ranging from the issue of booting and should a horse be booted, should a horse not be booted, the issue of a horse that's going uphill and they're at a trot versus a canter, versus how heavy a horse should be, to all those sort of the temperatures a horses can operate. So basically what we try to do is do a review of many things that have come in front of the commission and try to bring them forward. We also did some clarification in some of them in terms of the horse care that and driver condition and that sort of thing. So we've again, it has not been reviewed nor has it been edited in any substantive way. It was hard to get out since 2002 when it was originally written. It also deals with the fees. We're required to collect our fees that actually would cover the expense of this particular operation with the commission. We're suggesting a increase just based on the amount of time that I spend, that office staff spends, inspectors spend on the industry. It's not a huge increase. In real dollars, it is a huge increase compared from $100 to $500. Even at that, that may be an issue that comes up, may not. So that's what this is. I don't think I've been talking about changes for months and even years, and I think what this would do, for instance, the drivers of a carriage would have the same requirements of a driver of any other for hire passenger vehicle in Davidson County. They were actually taken verbatim from the other ordinances.
And the fee is now in line with all the other fees.
I'm sorry?
And the fee is now in line with all the other fees.
And I'm confident you'll hear some opinions, because I've shared the information that came to the commission staff. I think y'all have gotten some other things directly that did not pass through me.
All right, at this point in time, we will open the public hearing regarding the proposed ordinance changes to Metropolitan Code of Law, Section 12.54. I will also note for the record that we also received a statement in written form from Elizabeth Howe yesterday, January 22nd. And she sent us her comments on the proposed changes to the ordinance. And I understand that Ms. Howe was not able to be here today, so I wanted to say that on the record. all the other materials that I see that have been provided to us are from speakers who have submitted requests to speak, so we'll proceed. I've got a number here who've asked to speak. We're going to use the clock today and limit comments to 2 minutes. Of course, if we have any questions, we will not hold that against your time. At this point, I'll call Ms. Carmen Zuniga.
I'm going to turn my time over to Eddie Garcia.
All right. Jennifer Snyder.
I'm also going to turn my time over to Eddie Garcia.
Tina Doherty.
I'll also be turning my time over to Eddie Garcia.
Brenda Smith.
I'm turning my time over. Eddie.
Johnny Smith.
My name's John Smith. I own Sugar Creek Carriages. I'm also a master farrier certified through the BWFA and also the Horse Equine Research Center out of Lafayette, Georgia, and diplomas with the Oklahoma Horseshoeing School. I've been in business for around 20 years here in Nashville with the horse-drawn carriage industry. And back when Leo Waters, back in 2002, wrote these ordinances, I was part of it along with Mr. Fields. There's nothing wrong with the ordinances as they are. There's about 3 or 4 of them that directly affects the well-being of horses and also passenger and driver safety. And what would be best is for all the carriage companies, including Mr. Fields, to have a meeting and go over, because this is also going to cost us around 1/3 of our yearly revenue. We're already at a disadvantage from moving the carriage stand around so much. This is going to be another thing that's going to hurt our industry, and let alone the safety aspect of it, and also the endangerment of the horses. So that's what I'm requesting, is if Mr. Fields could gather a meeting with the other carriage companies and even certified farriers or people in the industry. And we do have documentation that the majority of the whole horse carriage industry in the United States is backing pretty much what I'm saying. So that's all I have to say on this.
What are the particular proposed sections that you have an objection to?
The major one is faster than a trot going up hills. If you're into it, the next step in a gait is a canter from a trot. Now, if you're in a canter, you've only got 1 foot on the ground, and there's periods where you don't have no feet at all on the ground in a canter. Now, you combine that with the aspect of possibly no shoes and a small horse, you're looking to have a horse laying on the ground hurt, and that's very unacceptable to me. Plus, you're going to endanger the people, the driver, the horse, and the people that's carrying it. The next issue is, I don't know if you folks know this, but veterinarians, they go along with farriers to determine the correct shoeing, because that's the specialty of a farrier, is trained in the different gaits, the travel, and from the knee and the hock down to the ground. That's what we specialize in it. So we work closely with vets on therapeutic and corrective shoeing and travel. We try to fix these issues. So if you let a horse with no shoes, which if there's a vet going to sign for that, like it says in this ordinance, I'm going to go up against him, because that's not correct. And the whole industry's on my side with this. It's dangerous. No shoes, you don't get as much grip, and you get wear and tear. There's no cushioning between the sole of the horse's hoof to the asphalt. A screw from a license plate could puncture up into the sole. Plus, you're ripping and tearing on the hoof wall itself. So then, and the next one is the temperatures. About 2 years ago, I purchased 4 mules so because we are allowed to work into 95-degree weather. And for the past 40 years, since horse-drawn carriages has been reintroduced into Nashville, there's not been one single incident where we've had a horse over heat exhaustion and the cold too. If you the temperature should stay the same at 25 degrees low and 95 on the high. I grant you, if you go through the change, then allow the mules to work from 90 to 95 and also from 35 to 25, because that will affect not just me but other companies also. That's about all.
Mr. Smith, could you help me here and refer to me the section involving the speed of the horse going up a hill?
What section is that, Cam?
It is 1254 200, number 13. I believe it's, number 13.
The way the proposal is, I think it says
Section 23.
the proposal is saying it could go faster than a trot. Well, faster than a trot is canter. Then you've only got, when you're in a trot, you've got 2 feet on the ground at all times. When you're in a canter, you've only got 1. That's not no traction. And the horse, they do go a little bit quicker going up a hill, but they will not get into a canter unless that horse is too small for the load that it's pulling. Now keep in mind, we're able to have 9-passenger limos at 165 pounds per person. That's 1,640 pounds, including the driver, which is 10 people, plus the 9-passenger limo at 840 pounds. Then you've got another 150 pounds of harness, batteries, accessory, plus the weight of the horse. If you're using a 2,000-pound horse, we're pulling 4,600 pounds uphill. To have no shoes on a horse doing that is totally ludicrous. It's dangerous. And then you put on top of that cantering when you've only got 1 foot on the ground. That's not right. And plus too, the horse, they'll go into a trot, but if the horse is too small and it sees the hill coming up, it will try to get into a canter at that point. But get a bigger horse, you know. Don't try to overload that horse with a 9-passenger limo. Put it on a 6-passenger vis-a-vis.
I'm sorry, I know I'm new, but are they not required to have shoes? Is that the issue?
Well, yeah, they are. They are right now at this time, but there's an exception in the proposed that if you've got a letter from a veterinarian, you may run this horse without shoes. That's unacceptable.
I agree. Where is that?
Which one is that, Cam?
Section 27.
It's number 1 of section 27.
Okay, thank you.
I'm looking out for the safety of the general public, the horse, on the horse's behalf, and everything concerned. And I am trained and I'm knowledgeable of this.
What is your background, sir? I don't know you. I'm sorry.
I'm a farrier. I'm a master farrier. I've been in horses.
Tell me what a farrier is.
A farrier is, you know what it is? Okay.
I'm a horse owner, so.
That's me. I'm a blacksmith. I'm a farrier. I've been doing the horse-drawn carriages for the past 20 years here in Nashville. And my mom's got a picture of me in East Tennessee when I was a year old on Tennessee Walker's back. That's me.
And Mr. Smith owns one of the horse carriage companies.
And is he here?
Yes, he's the speaker.
Oh, John.
Yes, Sugar Creek Carriages.
I actually think I have a picture of him and that horse in the files, so. I've got a big file. It's a big file.
She may have.
And like I say, for the past 40 years, we have had, when they was reintroduced by Earl Lemoyne, we have had no incidents on heat exhaustion or any illnesses contributed to low temperatures.
What's the section on the temperature proposed change?
Proposed is down to 90.
Section 29.
and from the cold point up to 35 degrees, which would affect, I believe that would affect Opryland also.
All right. Thank you so much, Mr. Smith.
Yes, sir.
Melody Robinson.
Hello, my name is Melody Robinson. I own American Melody Carriages. I would like to suggest that if the permit is to be displayed on the upper body, for security reasons, that possibly the last name and address of that permit holder and not have to be displayed on that permit. Also, for the driving school, I would request that if new drivers are required to go through a driving school, that there would be options for those schools. Right now, the only one that I know of is Mr. Smith's driving school. And I would also request that current drivers could be grandfathered in, as they already have been through the schooling of driving downtown Nashville. Some of them even before there was ordinances. For the cold temperature, I would like to request that we would be more in line with New York City, which is 18 degrees, or Chicago, which is 15 degrees for horses to operate. And as far as the barefoot issue, I have already provided sufficient evidence to this commission, and it has been unanimously passed by this commission that horses be allowed to operate barefoot pulling a carriage. And based on that approval, I believe that I was working under the rules and did operate my horses barefoot for over 2 years with absolutely no health issues or incidents of any kind, including safety, slipping, or anything that was detrimental to the horse or the public safety. On the part where the fee is increasing to $500, I would like to request that
Go ahead, Ms. Robinson.
in order to be more fair, I would suggest respectfully that possibly the fee could be $100 per carriage that a company is allowed to operate downtown. This would still increase the fee for all operators. As I am the smallest one, this would double my fee.
What's your rationale for not requiring the identification name?
I would like to
signage?
request that the last name and address of the permit holder not be required to be displayed publicly for safety reasons.
What would you offer as an alternative?
That there could be the same permit, but with our first name and the company that we work for.
You understand why it's suggested to have some identification of the driver or the person operating?
Yes, sir.
All right. And your alternative would be to put the first name of the driver and the company the person's working for?
Yes, sir.
What about a phone number of the company or
Yeah.
the address of the
I
company?
don't see a problem with that. And then, of course, the Metro Transportation licensing seal.
Mhm. Some of the companies have distinct names from their drivers. Sugar Creek's drivers are not Mr. and Mrs. Sugar Creek. So if a person wanted to make a complaint against a specific driver, if a tourist or a customer wanted to make a complaint against a specific driver, it would be hard to identify him then. Whereas
I don't know
with
of
your
any-
company, your last name is part of your company.
My first name is
Your
part
first
of my
name, I'm
company.
sorry, yes.
I don't know of any drivers downtown that have the same first name as any other drivers.
Yes.
So I'm not sure what you're...
So, okay, I see what you're saying. You said put the first name of the driver and the company name,
Yes,
the
sir.
address and phone number, whatever, and that would be sufficient to be able to identify the driver if there was a complaint.
Yes, sir. because if they wanted to go to the trouble of getting more information, it's on record with the Transportation Licensing Commission, but that way it wouldn't just be right there on display.
So right now, under the proposed regulation, the address, it would be the personal address of the driver or the address of the company?
As proposed in those regulations, on our permits right now, it is our first and last name and our address, I believe.
Of the permit holder.
Yes, sir.
Yeah.
Aren't the permits transferable from company to company?
No, sir.
I believe not without our approval.
You mean driver to driver?
Oh,
Driver,
driver.
yeah.
Actually, there's not a prohibition on the horse carriage. They're the only ones. One of the things we'll probably be suggesting today is we did have some recommendations that came in that we worked through that we would add that are not unlike what Ms. Robinson suggested.
I'm sorry, I misunderstood that question. Yes, drivers are allowed to drive for other companies, so I do see that point.
All right. Thank you, Ms. Robbins.
Can I just ask a question? Can you clarify for me what you said? You made a comment about the shoes issue and that.
Yes, ma'am.
I don't have that history. Can you explain that for me?
Yes, ma'am. In August, I believe, of 2016, I presented sufficient evidence to this commission, and they unanimously passed a change to the ordinance for shoeing that the owner be allowed to work their horse barefoot as long as it was monitored by the farrier, the veterinarian, and the owner as well. There was a meeting prior to that regarding rubber shoeing, possibly requiring everyone to have rubber shoes. And at that meeting, it was stated that everyone should be allowed to choose for their own horses what they felt was best for their horses. And I would just respectfully ask to have that same courtesy. As far as the research that I've done, which is pretty extensive, it is better for the horse to not have a shoe, especially a metal shoe.
Okay, so it looks like the exception is still in here, right? If a certificate holder wishes to work the horse without shoes,
yes, ma'am.
Veterinarian approval must be submitted. Okay.
Well, just to clarify, Sue, in August 2016,
Yeah.
there was a vote. There was no change to the rule.
Okay.
It was just part of a recommendation to an ordinance change, which is finally in front of us today.
Okay, I see.
So the current rule, shoes and boots are required.
Except in this circumstance, right?
Well, this is a proposed rule.
Okay. Okay, I gotcha.
Thank you, Ms. Robbins.
Thank you.
Thank you.
Tricia Vector.
Lebkeck.
Thank you.
Hi, my name is Tricia Lebketcher. I'm sure most of you remember me from Nashville Animal Advocacy. So, again, we're not affiliated with horse carriages. We don't own any of them. We just wish that, we do what's best for Nashville and our horses and human residents. So Nashville Animal Advocacy applauds the Transportation Licensing Commission's proposal for updating outdated code and putting tighter restrictions that protect both horses and humans in our great city. We especially appreciate Section 29. I know you've heard some backlash on that today, but with the tighter temperature restrictions, which are long overdue. However, we take issue with a few points in the proposed changes to Code 1254. Those are the allowance for horses to be unshod with veterinary approval and the allowing of cantering of horses pulling carriages. At 90 degrees, which is the new proposed working horse limit, it was previously 95, asphalt temperatures can rise to 150 degrees, which can make it extremely uncomfortable for a horse without shoes. Without shoes, horses can pick up debris from the streets, such as nails, rocks, and gravel, which can cause serious damage to their feet. We also take issue with the proposal allowing more than a trot uphill. This can cause ring bone, side bone, navicular, bruised heels, arthritis, and damaged joints. Additionally, allowing horses to walk at faster speeds is always more dangerous for public safety and for the horses themselves. It's our belief that if a horse must gain momentum to go up a hill, the horse is obviously being forced to pull too much weight. So we suggest respectfully that the Commission look into these issues further before deciding to pass these proposed changes. Thank you.
Thank you. Paul Morrison.
I'm Paul Morrison, owner of Southern Comfort Carriage. I have a question and also a disagreement. We'll go to the disagreement is once again on the weather. It's several years ago, I had the temperature lowered when Brian McQuistion was here because of all the other cities, like Melody pointed out, 18 and 15 degrees. So he dropped it down to 27 or 25, whatever it is now. And then the 95 was reached also. And every carriage person or company has abided by those. There's been no issues and no problems. A couple of years ago at Opryland's, first time it ever dropped below the temperature that we were required not to work in. I even called Billy and said, please send me an email so I can show it to Opryland that we can't work below this temperature, which he did. So we all abide by those rules. I would like to see those stay the same. I had a question and then a suggestion. The question, maybe I'm just not clear on it. On page 2, it would be section 10. Maybe y'all can clarify it for me. The way I read it, it says that, is that saying that if an employee that applied to work for you, if they lied about their application, that the owner would be held responsible?
The driver has, I'm sorry, Mr. Chairman, may I speak?
Yes.
If you'll, that does not apply. In other words, the owner would not be accountable for somebody who lies on an application.
Okay.
The driver himself, if you go back into the rest of it's very clear that they have to be truthful in their application process. Again, just as all the other companies, that's what we're trying to do is make sure everybody's at the same level of compliance.
All right, thank you. That clears that up. The only suggestion other than that is section 2 on the first page on the money situation. There are smaller companies. I would maybe suggest make it $100 per carriage per permit. That way the smaller companies, it may be $200 for them, and it would be higher for the ones of us that have larger companies. Would pay per carriage, permitted carriage.
Thank you, Mr. Morrison.
Mr. Morrison, I want to ask you a real quick question because we've heard two people now suggest a sliding scale on the fee. Help me remember, what is the differences between the number of carriages in the larger companies and the smallest company that you're aware of? Just
there's the number permitted. There's a limit of about 4.
Mm-hmm.
They have 5. I have 4, and the other companies have like 2 permits. So maybe
our
3.
range is 2 to 5.
Yeah.
Okay. Thank you.
I'd appreciate consideration on that weather. We're not hurting the horses. There's no complaints, no problems.
Mr. Morrison, what's the section with the proposed temperature change?
What was that?
What's the numbered section for the proposed
Oh,
temperature
that was,
change?
It's section 29.
it's back here.
next to last page.
Here it is. It's section
I see.
28, section 29, the paragraph right under section 29.
Thank you, Mr. Morrison.
Okay.
Mr. Eddie Garcia.
I'd like to have Mr. Blackburn speak for a couple minutes before I go up, please, if you don't mind.
Mr. Chairman, really all I wanted to address was that we are talking about two broad categories of changes. Some are what I would call administrative. I think the idea of more authority in the hands of the director for some of this complaint process sounds reasonable, I believe. Then there's a whole category that has to do generally with horse safety. I think these issues involve matters that require more exploration and more information from unbiased, uninvolved, independent experts. And my suggestion was going to be that that aspect of this be deferred, and that, as Mr. Smith suggested, and I doubt there's very much disagreement with this, that the operators be allowed to meet with Mr. Fields and staff, and that actual information that demonstrates these issues that we've discussed today be presented so that this can be done correctly. Most of all, the disputes we have here have to do with animal safety. And then finally, in terms of transferability, section 12.54.290 says, a certificate of public convenience and necessity, horse-drawn carriage permit, carriage driver's license, or an identification card is assigned to one person or company and is not transferable. So that means that one of Mr. Smith's operators, for example, could not go to work for another company for one night without prior permission of the commission and alteration of the certificate. Can they work for other people? Well, there's no non-compete. There's nothing in that context. But this requirement requires that the work be related to a specific company, and that's obviously for the purpose of enforcement of your regulations. And finally, this discussion about shoeless horses respectfully is misleading. Ms. Robinson has a number of matters today in which she is defending. There was a vote by this commission explicitly saying that operators could choose which shoe, what type of shotting, if that's a word, they would use, because they had the interests of the animals at heart. But there was never a provision allowing no shoes at all. In fact, that was made very clear. One of the accusations that has been made against Ms. Robinson is that she defied that order, and in fact she is presently subject to suspension because of that violation, and there are complaints in this agenda today having to do with further violations of that. The question of whether horses should be shod requires expert proof, not the motivated testimony of one single interested individual.
This is a complete packet. Some of you have received some letters, third parties. That's the entire package. I'm not going to, Eddie Garcia, I'm not going to belabor or be redundant to save time, because we don't want to be here today with the inclement weather. Mr. Blackburn sufficiently addressed the issues, and I'll just echo it, that it just makes proper sense and better decorum in your appointed positions by the City Council to look at this and discuss it, deliberate it, and then you make a recommendation. We understand that you're not here to vote on it today, but I think in the interest of the industry, and we're all for public safety, of not just the animals, but the passengers and everyone else on our streets, that it behooves you to consider deferring this matter. There's no urgency today to do this. I think we can all be adults in a room, and Mr. Mr. Fields and I have had a conversation that despite the animosity between the carriages, I think at one point we can all come to an agreement that these rules are probably warranted. I have spoken with Mr. Waters, and he's the original sponsor when he was on the city council, 2002. He was surprised that it's back up, but he said, wow, it's pretty interesting. It does need to be changed. There are some things that are archaic and obsolete, but there are many items in this that we don't have sufficient time today in 2 minutes, in 4 minutes, or 5 minutes to really get into a deliberative discussion. We all have the interest of making this ordinance applicable, fair, and concise so that the inspectors that are out there or Metro PD or whoever is given the responsibility to enforce these have a clear understanding. Some of these provisions in here are just not fair to the industry or to the animals, and we all want to be on the same page. I think the request and the suggestion that Mr. Blackburn put on the table is one that I would urge you to consider. Defer the matter so that we can all sit somewhere here at the TLC. If a security guard needs to be posted, then so be it. But I think in the interest of coming up with something that's good, that's strong, that's viable, that can probably withstand another decade or so, the interest of having everybody sitting at the table, going over each item. I've got the 10 pages printed out, and I've got notes all over, and I'm probably a very meticulous person. But I think it behooves you all to consider deferring this matter to another time when the staff and the carriages can come together. There's expert letters in there from third parties who are far better acquainted with this subject matter than I as a horse owner myself. But I think it's very important to really sit down and go through these issues line by line as any other legislative body does. Mr. Fields and I have had the pleasure or displeasure at some point of working for members of Congress. Despite what's happening now in our Washington, D.C. environment, it is very optimal, very productive to just have a conversation with all the parties, all the stakeholders, so that we can give you something that we may agree on some things, we may not, but we in earnest can say, we've sat down for 2 hours, we've discussed all these issues from line 1 through the very last page, and I think at that point, your recommendation to the council will be well thought out, and city council members with whom we may also have conversations at that point can pass something that's meaningful and does protect the animals, the industry, and the livelihood in Nashville. If we didn't have tourism in Nashville, we would be very much a destitute community.
Mr. Garcia, which proposals are you saying are not fair to the industry or the animals?
They've been discussed earlier. The shoeing, the cantering, the temperature, the issues related to the driver's permit. There's quite a bit, and some of them have already been addressed. I'm not going to be redundant, but I think that demonstrates the requirement that we should have an opportunity to sit down, go over it line by line. Again, at the end of that, if it's one meeting that you all recommend to the staff to have, then at the end of that meeting, we all agree. What comes out of this meeting is something that goes forward.
What is the issue with the driver permit?
It was addressed. The permit, it's too large, number one. But two,
you're talking about the notification that Ms.
Yes. It's pretty large. It's 5x7.
Yeah.
Those are kind of like the ones the vendors on the street corners wear. I agree with what Mr. McNally said at some point let's look at what is pertinent to put on there. Mirror the taxi company licenses, and I haven't ridden a taxi in a long time, but certainly the photo, the name, and I believe, and we conferred quickly, first and last name so you can identify who it is, but the photo, the name, the company, maybe assign a permit number 1 through 40, whatever number of permits are issued. But the personal information of their address or anything else puts that person in a very precarious situation. If you have a person that's for some, like Mr. President Trump's saying now, bad hombres out there, they're going to find out Miss Susie so-and-so lives at this address. And I don't think we want to put them in that situation. I think you have the responsibility to make sure that they are safe as well as they are doing their profession.
Mr. Garcia, it seems to me you've very adequately articulated your position on the permit issue. Why do we need to defer anything for further enlightenment?
There's 9.5 other pages of things.
Well,
you've identified 3 others, the shoes, the cantering, and the temperature.
So tell me, temperature-wise, why you say it shouldn't be set at 90 degrees.
The temperatures, there's a letter in that packet from a couple equine professionals. The horses can withstand temperature. We all know that horses mostly outside or in a barn that's most people can't afford to heat. So they can withstand those temperatures. The opportunity that Mr. Smith has, and I don't think any other company has, he's acquired mules. There's evidence in those letters that mules can withstand temperatures at the lower extreme and at the higher extreme much better than horses.
When did you get these letters?
We've been working on it for about a week, trying to get people's schedules. So those letters were obtained in the last 2 or 3 days. Some people chose to send them directly to Mr. Fields, and I provided Mr. Fields' email.
Mm-hmm. Yeah.
Some people at last minute just handed them in yesterday.
And we've received some of the ones that Mr. Fields has
Yes,
emailed
and
to
then
us.
the rest of it in the packet that I just handed.
Curious why this packet comes today to us instead of earlier, like the other information you had sent.
I can't force people to stop what they're doing in their private professional lives. So in the week that I've tried to get it, some people were out, some people were on vacation.
So you didn't get it till yesterday?
The last one came in at 10:30 last night in an email. She had problems with some legislative things that she had in Washington.
So summarize what the letters say as to why a horse should be operating over 90 degrees temperature.
Well, the complexity is that some of them, even a meteorologist, we're not taking into account the temperature heat index. And we live in Nashville, Tennessee. There are other areas in our country where the heat index, humidity, and tied to the temperature can put us in a situation that I don't think anyone here is a professional meteorologist. The issue that one person addressed, and I did speak to the letter in there from the Calvary group, and she pointed out, and she is also a horse owner, when it's 80 degrees in Nashville, there could be humidity, there may not be humidity. So if you do compile the two indexes, that weather is perfectly fine for a horse to operate. But I want to point out the fact that Mr. Smith has mules, and the discretion on the owner to exercise and put those mules into employment should be upon that owner. I don't think any other company has mules. Those mules they're in the desert, they're in the Himalayas, they can withstand these temperatures.
Anything else?
No, just there's many more sections in the proposals, but.
And you're here on behalf of whom?
Sugar Creek.
Okay, and that's Mr. Smith.
Yes, sir.
And Mr. Smith asked us just to point blank not recommend these revisions, to keep the old rules of 2002. That's what I heard him say. So.
2002.
That's what you want to keep,
on temperature,
Mr. Smith, right?
That's what's in existence now, sir.
Yeah. You don't want to see any changes.
We're talking about temperature?
No, there should be some changes, but there's so much to this proposal. It's, there's a lot. There's some things that do need to be addressed and changed, but there's a lot in this proposal, sir.
Well, just so I'm clear, Mr. Garcia, if we reviewed these proposed changes and declined to make the change to the shoes, allowing a cantering of a horse up a hill, or the change in the temperature spectrum, and then perhaps modified the driver permit card, you would not have a problem with us recommending these proposed changes with those modifications?
Allowing the discretion of shoes or no shoes?
No.
What's been submitted today?
Keeping the ordinance as it is.
As it is,
with
related to
respect
shoes
and boots.
And nothing to exceed a trot.
Correct.
And the temperatures as they are now in current code.
Correct.
And the driver's permit modifying it so that no personal information's on it.
Correct.
Those are four of probably 25 or 30 other items. Again, because we painstakingly took the time to go line by line, we've pointed out some things that upon discussion we made the rationalization with Mr. Fields or staff and legal is, oh, that makes sense. But give us the opportunity to give you our 2 cents about it.
So there are other sections?
There are other sections. I mean, Section 14, dealing with the criminal background.
If we could keep them as it is for those 4 areas, yes.
Let me make, if I may, Mr. Chairman. So I want to make sure, because I want to make sure we're communicating from both of you. Mr. Smith's the owner, but I want to make sure all are. there are other issues that you may have, but the four issues that the chair just discussed, in other words, we would, if the commission were to go in and remove for consideration or not recommend to the council 13, section 13 or number 13, which appears in section 23. That section says not permit the speed at which a horse-drawn carriage is driven to exceed a trot unless the horse is pulling a carriage uphill. So for instance, at your recommendation, we would take that out. We would then go to section 27, which
he can't exceed a trot.
in other words, no, we would just take this out of the recommendation altogether, and the current law would stand as it is.
Yes.
There would be if we were to do that I think the chair's heading. Then we would take section 27, and we would take the next section where it's talking about the shoeing. What you're saying is, your problem is with that section, if we took that out and left it the same as it is today, that's fine.
Requiring shoes.
Correct.
Protecting the horse's hoofs, yes.
The third thing is the section 28, which is talking about the temperatures. If we did not make any recommendation to the council.
Section 29.
I'm sorry, 29. And then we modify the application of the permit. Those were the four issues.
Those are if we were to identify, those would be four top.
Okay.
Those would come up on that TV game that comes up, the number 1 through 4. That would be it.
Family Feud.
Yes, sir. I couldn't remember the name.
And while you may have concerns about the others, again, most of what we're talking, for instance, the driver application, that is verbatim, I think, verbatim out of other ordinances that this commission has considered, the public has considered, the council has passed, and we've been operating under, in some cases, for several years.
And I agree with you. Section 14 is that section.
And also what Mr. Roberts said about the identification being on the person, but it needs to be small, because it's the way that permit is now, it's huge, and the personal
It's the same size as taxi cab drivers, but again, during your discussion, I'll be glad to give staff opinions on those four issues.
But the personal information don't need to be there. You can number the identification or a number system or something. Because it's too dangerous.
I just wanted to clarify the four issues.
Mr. Fields, is section 27, part 1, the first item under section 27, is that if you took out the final sentence of number 1, so a permittee with an animal used in a horse-drawn carriage must adhere to the following regulations and conditions: be appropriately shod and trimmed, and shall utilize rubber-coated pad or boots, or open steel barium tipped shoes or other shoes approved by a veterinarian or by commission rule. If a horse loses a shoe while working, an easy-type boot may be used to finish the scheduled workday. Is that language different from the current rule?
No, it's old. That's the original
that's
language.
Verbatim.
The one thing on that, it should be approved by a veterinarian and a farrier, because the vets work hand in hand with the farrier, sir. That they go on our recommendation too.
In most cases, a veterinarian will refer to a certified farrier.
Again, the section you just read is what's in the ordinance today.
And the only revision is the last part there, if the certificate holder.
Correct.
Yes, sir.
That's what legal added.
Okay.
And that was, well, again, I'll be
Which
happy
is
to
consistent
discuss
with
where we
what
got
we-
to this
yeah.
with
Yes,
the commission.
yeah,
That's
yeah.
fine.
With regards to Mr. Fields' comment, section 14, dealing with the criminal background, yes, everything in the proposed is identical, verbatim to the current law. The exception that we had, as a matter of fairness, is number 4 under paragraph C. It basically just deals with expunged records. This is something that comes up often in this commission during debate of applicants. It's my understanding, I'm not an attorney, it is against the law to ask a person to share expunged records. I think it's a criminal offense in Tennessee to ask, but I may be incorrect. There was a video at the beginning of an October 2017 TLC, and I've taken painstaking time to view a lot of hours. An individual who I believe is here today was asked about, why didn't you submit your expunged records? His attorney came up, it was a female, and she explained, and I believe Mr. McNally, Mr. Hernandez were on the commission. She explained that there seems to be a disconnect between the clerk and TBI. and I think Mr. Hernandez, you asked, well, why are we getting it, or Mr. McNally did. That is an issue. Something that needs to be rectified between the clerk of the courts and TBI so that expunged records are not only not asked, but they do not show up. But when they do show up, that a person is not put under the ringer to say, why didn't you disclose expense? I don't think it's, I'm going to defer to Mr. Blackburn.
If I may, I've actually dealt with that issue in the context of the nursing board in a case that went to the Court of Appeals. The law in Tennessee clearly at this point is that an expunged record treats this as if there had been no charge at all. And so a person can even deny on a job application that he had been convicted of the crime if it has been expunged. And that law has evolved over years. I think it's Butler versus the Tennessee Board of Nursing, I think is what it is. But it's clear that an expunged record, I don't think it's illegal to ask the question. I think it's not required of anyone whose record's been expunged to answer it.
So that's another issue that perhaps demonstrates, in my opinion, the need to, let's have deliberative.
That sounds like that's a universal concern for all of our
I think it would be.
I can speak to that issue a little bit with the chair's permission, is that there is a provision in the Tennessee Code annotated that states that the Transportation Licensing Commission, in performing this function, that you all perform licensing persons to perform, vehicle for hire type duties, it serves a law enforcement purpose. So you are actually able to use those records like a law enforcement agency can. So that is a distinction between what you all can do and perhaps what can be done in other employment spheres where such records may be requested.
Thank you, Ms. Costonis. Thank you very much for all your comments, Mr. Garcia.
I think that's somewhat covers most of the pages.
At this point in time, we'll close the public hearing and allow this to go to deliberation by the commission. It sounds like we've heard from a lot this afternoon regarding this proposed ordinance to the council, and it's pretty clear to me that, as Mr. Garcia aptly stated, the top 4 issues have to do with the proposal regarding the possibility of no shoes or boots in use by horses, the proposed provision that would allow a horse to exceed a trot when going uphill, the narrowing of the allowed temperature range for horses and mules to operate, and also to address the issue regarding the driver permit and the information that is displayed. It seems to me, based on comments from the public today, that by and large there has not been much suggested or objected to regarding the proposed changes to a lot of the processes and procedures, with the exception of 1254.140 criminal background investigation. There was a question raised by Mr. Garcia and Mr. Blackburn about the failing to disclose an expunged record. And we've heard from Ms. Costonis that there is an exception in the Tennessee Code annotated allowing the Transportation License Commission to specifically ask about expunged records. So we are not violating the law of Tennessee when we ask that question. So really it's just a policy decision of do we want to continue to disqualify an applicant if they fail to disclose an expunged record.
The other thing about Section 4 there, it says has failed to disclose any criminal conviction. Once a record is expunged, that conviction has already been dismissed, and whatever guilty plea or conviction has been withdrawn. So we're not even dealing with 4 there when we're asking about expunged records. And Mr. Blackburn was correct in what he believed the law is. On expunged records, you can ask on an application if someone has had a case expunged. Tennessee statute specifically provides that the applicant can decline to answer it or can answer, no, I have not been. And in fact, if they're called under oath to testify, they can testify under oath that they have never been even arrested, let alone convicted of the offense that's been expunged, and they cannot be subject to perjury. Now, the employer can decline to hire the applicant if they find out about the expunged offense.
And let me clarify the TCA provision a little bit. It doesn't specifically say that we can ask this question, but it does subject applicants for this type of position to a fingerprint background check that would show expunged information, and specifically clarifies that for purposes of reviewing that information for this purpose, which I think it actually requires you to consider it, you would be seeing the expunged information. So when we ask the applicants for it, we're asking them for something that y'all are going to get and have to consider anyway. So it's just a question of whether they disclose it accurately.
I hate to confuse or to add more confusion to the situation, but I want to bring something up that's been on my mind for a while, and I've talked to Mr. Fields about it, and it deals with finding people not to be qualified if they've been on judicial diversion, released from incarceration, probation, or parole within a period of 7 years. I've seen several people come up here who are applying for cab jobs or other positions, and they were released and placed on parole 5 years ago, and they've been model citizens. They've been complying. They've been reporting to a parole officer. They've been drug-free. They've been employed, and they're wanting to step up to become a driver of a wrecker or a cab driver. And we've had to look at them and say, no, we can't approve you because you're a disqualified applicant because you were released on parole within the last 7 years. And it's something I've talked to Mr. Fields that I'd like to revisit on all of these ordinances regarding a qualified or unqualified person. Frankly, I think someone that's actually being monitored by a probation officer on judicial diversion, probation, or even a parole officer may actually is someone who we know another entity is watching them, is drug testing them, and things of that nature, and maybe even a better qualified individual than someone who comes up here who 10 years ago got off parole, and we don't know what they're up to at this point. So in Section 14, subsection C1, I'm not saying I want to necessarily modify or change it today, but I am very interested in looking at all the ordinances for applications for various different, for hire vehicles, and looking at that carefully. I don't know how that impacts the recommendation here today or not. So.
Well, one of the things on an issue like that, for instance, if you have some specific changes, this wouldn't, in other words, we could actually begin your thoughts with this particular ordinance. Assuming you were satisfied, assuming it passes council, it would not be unusual for us to go back to council and basically take that same section and go to 672, 673, 674, 675, 681, 1254, and 1262 of all of the ordinance that we're responsible for, and make the changes. In other words, we do that in total, I guess, that would basically say your language and say this, 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 and this, and take it back to council. And, because if you make the change, if it comes up, we'll have to defend it. In other words, that's what I and legal would do with the council if you wanted to make the recommendation. So I know you've been thinking about language, so it would not be inappropriate if you're ready for that to actually start with this one.
Okay. Is it just a matter of reducing the number of years prior to the date of application?
I think it is.
But is that only dealing with parole, probation issues?
And judicial diversion.
And in other words, it wouldn't necessarily be involving convicted, pleaded guilty, nolo contendere, but it would from placed on judicial diversion and so forth?
Correct.
Further?
Because a person who is coming up before us on judicial diversion or parole or probation would have pled guilty significantly earlier.
Then we could basically take this paragraph, split it, and add language to go after has been convicted, pleaded guilty, or nolo contendere for the last, what your language is, 7 years if you want to leave it at 7, and then whatever the language is, or has been such and such, has been the others within the last 2 years, or no years at all, continues to be on this, this, and this. and then legal could craft it as we prepare it for the council. If crafting was needed. You're eloquent. I would not question your eloquence.
And then, if you don't mind me asking, Section 4 has some language in there as well about placed on diversion, probation, or parole. And that's a 5-year period of time. What is that addressing? Because it doesn't say a disqualified candidate. It doesn't say can't apply.
One second. Let me make sure I can get this one in the context.
It's the first page at the bottom.
If you, basically, this language was taken from other ordinances that we've passed related to the applicant for the company. Doesn't apply to the drivers, but the applicant of the company. If you look at section 030 now, what you would find in B11 would say, I'm sorry? Yeah. In other words, basically the requirements that we established in 2002 are very different than what we have established for other industries that we regulate in 2019. So basically what this would do is bring up to date, I'm getting a nod from Ms. Ladd, it would basically bring up to date what we now believe to be the way we hold companies that are for hire companies today accountable was different than what we held in 2002.
In other words, our goal is when you look at the low-speed vehicle ordinance with respect to who is eligible, you should be able to see that mirror language in the horse-drawn carriage industry. And you should see the same language with respect to, towing and booting. And so we're trying to make them all be uniform so that we don't have to deal with the inconsistencies in each section.
Mm-hmm. I just saw the language there in Section 4, whether the applicant or any employee. So I was wondering what that was applying to or referring to.
This is the code section that I was referring
Again, basically what it's doing is requiring of the owner. Obviously, we do have it may be appropriate to take or any employee because again, employees are dealt. So it may be that we would strike or any employee because again, this is basically aimed at the owner.
Okay, so this is at the applicant who wants to become an owner of a horse-drawn carriage company.
Correct.
So I would think that we'd want to take or any employee out of there.
Correct. I apologize. That's probably something that we should have taken.
And I would agree. I think maybe an applicant who wants to be an owner may have to have or should have a higher standard regarding how long they've been off probation or parole, and then 5 years probably is appropriate. As far as for the employees, who often may be someone who's been released and is on parole and is trying to get a job, what I would prefer to see is that we just completely strike judicial diversion or being released from incarceration, probation, or parole within a period of 7 years, or strike out judicial diversion, probation, and parole out of there. And instead, anyone who's applying and on their application admits that they're on probation, parole, or judicial diversion, and I would even put in their pretrial diversion because that's another form of diversion, has to appear before the commission before a permit is granted, and we're given an opportunity to question them and decide whether this candidate who's on parole, probation, judicial diversion, or pretrial diversion is appropriate to be issued a permit to operate.
So what we do is strike it in the way it is now and then add language that would say any applicant who has those things that you've named are required to appear before the commission for application review.
Correct.
Can you once again just say the words specifically that you want taken out so I can make sure that I'm clear?
Yes, going along one there at the very end is where judicial diversion, strike that.
Okay.
Then going down right below that, been released from incarceration, probation, or parole.
So would you like it to say has been convicted, pleaded guilty, nolo, placed on are
Well, you take out
within
the
a
place
period
down,
of 7 years prior to the date of application.
Yeah, and I would recommend we think about reducing that. Someone who's pled guilty, got a 2-year sentence, did their sentence, completed it, and now at the end of the 2-year sentence or third year after pleading guilty is coming forward, wanting to apply for to be a driver of a.
It had been 5 for a lot of years.
Yeah.
In 2015, we actually amended it. We extended it from 5 to 7, and began at that point. But it certainly was 5 for a lot of years.
I would recommend reducing it to 3. And if in the application you see that since their conviction they've had a number of other convictions, much like you do, Mr. Fields, you then recommend that person come before us for questioning. Sorry to take up time on a 5th matter, but it's one that's been bothering me for a while. We've seen several people who were fine candidates, fine applicants, who we had to reluctantly say, sorry, you got to come back in 3 years or 2 years or whatever. And they're just trying to get a job. And this often these jobs that are available that come before us are the ones that people on parole can get jobs on. That didn't make much sense, but there's a lot of people applying who are on parole for the jobs that come before us. Do you want to try tackling the easy one regarding the display of the driver's permit?
And, Mr. Chairman, if I may, there are a couple of other things I'd like to say. One is there's language that also talks when they expire. One of the things we do need to do is, and I neglected, I made an editing error, we need to let them expire at the same time. We do that. So they all expire, we begin renewals on February the 1st. We end renewals on February 28th, so they all expire on March the 1st. So we would like to continue that practice of the commission. That way all the driver permits, and in other words, all the companies come in at the same time, which means in this case 4 companies and 28 drivers. They all come in that time period, we deal with them, and then the next year they come in the same period.
So with respect to Section 18, where we say that each driver's permit shall be issued for a period of 1 year, we're requesting that we be able to edit that and put a start date and a cutoff date for clarification.
Yeah. Very similar to what we do on all the others.
Why would you pick a month for the leap, potential for a leap year?
It's one of the things we look forward to every 4 years, actually,
Like
Mr.
for
McNally. When it happens, it certainly is an interesting time.
So for one day, everybody may be able to operate with an expired permit.
It's a free gift that we think the people of Nashville should have.
I do not want to disturb your 4-year fun time.
The other thing that I wanted to be clear on, in 2002, when this original draft was done, Metro Legal and I spent a lot of time, spent multiple meetings with Mr. Smith and several others drafting. Councilman Waters did carry the bill in council. I thought about having meetings, and basically when it came back to it, I recall the last 2 years of meetings with the Metro Transportation Licensing Commission. The conversations that I saw between the companies, the drivers, and others in the same room with live television, and they're in the commission in front of them. The conduct they had, I had no confidence, and I'm still questioning whether I'd have confidence we would have any meaningful dialogue. Mr. Blackburn and I have had conversations. We've talked about, the fact of trying to get conversation among the companies. I've talked with the other owners about conversation. I'm not confident. What I would say is the issues that have been brought today, if the commission felt like it needed to remove those 3 specific issues and then allow us to modify the application or the permit very similar to what we have done over the years with the taxi cab drivers. We still have large permits because cab drivers, there's a place to mount them, and that we place them so that people can see them. But if the commission were to move forward, remove the 3 offending issues, make the edits and the other additions that y'all have suggested, I have never refused to do, as the commission has said, in the many years that I've done this. I would be happy to try to have a meeting. By the same token, I don't have the confidence that I wish I did have. But that those specific issues are there for reasons. One, the booting issue or the shoeing issue was actually dealt with by the commission. So I brought it back to you as you sent it to me the first time. The issue of cantering was, again, an issue that came in front of this commission. Their testimony was given that horses have a natural desire and tendency to canter versus trot. I do understand cantering. I do understand trotting. Mr. Smith, I think, knows I have not kept my certification, but I was also a certified horseshoe inspector and spent time at the same school he went to. So I'm not an expert and don't claim the farrier title, but I do know a little about shoeing, and I do know a little about hooves, and I try to keep up with the best I can. So those 3 issues, and then the temperature has been an ongoing issue. I spent 3 hours over the holiday weekend past working, trying to help, and obviously we weren't able to achieve what the company had wanted us to do because of the temperature. But I think the issue of temperature, if we raise the temperature, we don't have the issue of ice because it's not going to be frozen at 35. By the same token, the comments that Mr. Smith said, a mule is very different than a horse. Its makeup is different. It's not a horse. It will work at hotter temperatures. It will work in colder temperatures. I have firsthand experience with mules in my childhood from many days with my grandfather, the logger, and that's no secret about it. I think mules are good. I will say, though, when I surveyed cities around the country, upper level temperatures, Chicago is 80, Portland is 90, D.C. is 89, Savannah is 90. Charleston is 95, but they have a feels-like temperature restriction of 110. It's not my job to try to take the business away from companies. I have no desire, and anybody that knows me recognizes I have no desire for a company to close. That's not my place. But I do want to make sure the horses are protected. By the same token, I will agree that there has not been an injury since at least 2002, where I've watched this industry very close. So for 17 years, I'm very familiar with, we've not had any heat issues. We have in some cities. We've not here. So if you remove those 3, you refer it back for additional study, we could certainly do that. Again, I'm not confident meetings would be appropriate, but I will do what you ask me to do. I don't think it's inappropriate to go back, ask them to provide additional information to those particular issues, and we can bring them back for a public hearing if need be, that you could then hear again just the 3 issues that they wanted to present. I'm done. Thank you.
Thank you, Mr. Fields.
Mr. Chair, just before housekeeping, there's one other issue that I was remiss in bringing up. It's on the basis of continuity, and it may be the same as legal said, let's mirror every other ordinance, and it applies in some other LSV.
If you could come up to the podium.
PHVs, the driver's license. So in section 13, it first appears, it's a valid Tennessee driver's license. It's item C1 under section 13. But then if we flip to section 20, item A, it speaks of another license issued in any of the 50 states. So if the requirement is to get a permit, you must have a valid Tennessee driver's license, then should it mirror in that other section? If I'm an applicant and I'm giving you a driver's license from the state of Tennessee as required, but another person is driving and they have an Ohio driver's license, it's just a continuity matter. Or perhaps I'm missing why that's in there. And it applies in LSVs and OPHV ordinances as well. Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, if I could say on the meetings, Ms. Rogers and I have worked very hard since the fall to call a truce here on what I call the ongoing carriage wars between Mr. Morrison's company and Mr. Smith, and I think with some success. You've noticed that neither last month or this month were there were any complaints made by either against the other. The things that we have now are just sort of ongoing, sort of random things that I hope will be resolved today. I know I can speak for Ms. Rogers because of specific conversations I've had with her. We had agreed already to try to meet to work out any problems we had. So I feel confident that at least these two gentlemen who together control the majority of all the carriages in Nashville would be willing to meet with Mr. Fields.
Well, thank you, Mr. Blackburn. I do know from speaking to Mr. Fields that a lot of time and energy has gone into preparing this proposed ordinance. There's been a lot of painstaking effort to get it right. The purpose of today's public hearing is to get comment from the horse carriage companies as well as any members of the public, like Ms. Lepketcher, and we've heard that, and we appreciate all your comments. You've made some effective points to us, and that's certainly why we're having today's hearing. So I don't want you to feel like we haven't heard you. I think as commissioners, we need to fairly and also effectively carry out, the commission's obligations to the city and to make a good recommendation to the council for proposed ordinance changes. We've heard quite a bit of objection to removing the shoe and booting requirement for horses, as well as any change to the trot limitation for horses, as well as the temperature change. And we've also heard from Mr. Fields that if we made those changes to the proposal, that it would still be a very fine ordinance proposal modification to the current set of rules that we have in place. So I think we ought to consider recommending the proposed changes with those modifications, as well as addressing the driver permit decal. And then, of course, Mr. McNally has raised an important issue that we should be thinking about for all of our ordinances that we're in charge of enforcing regarding the requirements that an applicant be automatically disqualified if he has been placed on judicial diversion or been released from incarceration, probation, or parole within a period of the last 7 years prior to the date of the application. I don't necessarily agree with Mr. McNally's proposal that we reduce the period of time to 3 years for an applicant from being convicted or pleading guilty or nolo contendere, but I certainly am open to discussing that further.
Between 3 and 7, what do you like?
Well, Mr. Fields mentioned that it had been 5 years for a number of years until 2015. I'm not sure why we made that change. I don't remember. I was on the commission then.
Yeah,
I just don't remember.
I can remind you, at the time, you'll remember that we were in the midst of drafting legislation that would deal with Uber and Lyft when they came to Nashville. As you know, in 675, in the ordinance that takes care of other passenger vehicles for hire, we have a section that actually deals with transportation network companies. In conversations of 14 months with those companies, we determined that some of the standards they had were actually higher than what we had. They actually required 7 years. Both companies required 7 years. We brought that to the company, to your attention, and you said, well, if Uber and Lyft are out there, and that was one of the things they recommended to us. So, of course, since then, the state legislature overturned our authority to regulate Uber and Lyft, but those were actually recommendations that Uber and Lyft brought to the industry of other passenger vehicles for hire. And then as we have had, after that, we had the low-speed vehicles, then we had the pedal vehicles, and then as we've modified ordinances, we've tried to parallel all of them in the same language. So the 7 years actually came from the conversation over transportation network companies in 2015 that you're here at the meetings.
Ms. Palmer, I know you're new to the commission, but it seemed like you had some you had a view regarding the shoe and booting requirement for horses and mules. Did you have any comment regarding the proposal that we allow them to go shoeless at the recommendation of a veterinarian?
Well, not being familiar with the history or what evidence, it sounds like you heard evidence before, so I don't know what evidence you heard or from whom. My feeling is that, my feeling right now is that horses need to have shoes, and that's from being a horse owner and from what I've seen over the years. I feel like that should be a requirement. But again, if there are letters or information that I haven't seen, then kind of in the dark on that. So I probably need to have more information as to what the experts have said on that and who the experts are to really comment any more than I have.
What about your thoughts as it's written, the way it's written right now, the proposal is that if you're going to go without a boot or a shoe, that a veterinarian has to approve it. Is that
correct?
And is there a period of time that they have to keep checking the hoof to make sure it's healthy?
The ordinance requires shoeing every 8 weeks, I think, is what it actually requires. Some shoe a little sooner. Horses all, and Mr. Smith could address it better, but I think I don't want him to get up. Horses shoeing, horses wear shoes just like humans. They wear shoes at a different level. There's going to be wearing different areas. Some are going to have to be shoed more often. Others are going to go as much as, again, 8 weeks, maybe some even longer, but typically 6 to 8 weeks is what farriers have shared with me over the years is a good general belief, and I'm getting a nod. So we do agree on one thing anyway, but that would be a typical time that you'd be looking at shoes. If that's the case, then if you were to go with allowing a horse to be barefoot, then you could also ask for the same kind of review for the same kind of time period if there's a concern.
Because right now, the way it's written, it says if they want to go without a shoe or a boot, the veterinarian approval must be submitted to the staff, evidencing acceptance of this practice within the horse-drawn carriage industry. And then we go into Section 2, subsection 2, it says inspected and maintained by a farrier at least every 8 weeks, or as necessary, records must be kept by the owner in the carriage of the dates, etc. It doesn't necessarily relate to being shoeless.
There were no further conditions that were placed just based upon the earlier motion that was made by the commission, but I understand, given the conversation, and I'd be happy to put some language together putting a condition that they have to, be re-inspected or whatever you feel comfortable with.
And as I understand, a farrier is a person who actually puts shoes on the horse, and a veterinarian is a person who checks the health of the horse. So if you're going to have a farrier inspecting a shoeless horse, a farrier is always going to come in and say they ought to be shoes on that horse.
Well, farriers go.
Okay, unless I've got it wrong.
Farriers do go beyond that in terms of the care of the horse hoof, because again, it's really something I wish we had time for y'all to study, because when you start studying the mechanics of the horse, the hoof, it's very intricate. The parts, there's again.
We heard someone testify that it was almost like a heart inside another heart to the horse. Yeah. Because someone had said they wanted that language to be veterinarian and a farrier to inspect, and
Mr. Smith.
Okay, my concern was whether a farrier would have it sufficient independence not to always recommend shoes.
May I have a comment to that?
Yes, Ms. Roberts.
There is actually such a thing as a barefoot farrier, which is the person who takes care of my horse's feet. He's classified as a barefoot farrier, and he inspects my horses every 5 weeks.
Excuse me. I'd like to know what his certification is, and also you work hand in hand. The vet works hand in hand with the farrier. So when you got a shoe on a horse or a boot, or a rubber shoe, you've got an air cushion that's going to keep the sole of that hoof off the ground. If you hit screws or sharp rocks, it's going to puncture the bottom of the foot. You have less traction. You've got hoof wall damage because of the breakover on the horse when he walks. It's going to be splitting, and your chances of having a blood trail from watching the horse go without shoes on greatly uppens. A horse don't belong working without shoes. And also, if you look at my packet that I turned in to you, the industry is backing what I just said. Kona and the Cavalry Group and the Horse Equine Research Center in Lafayette, Georgia.
Mr. Chairman, may I add?
No, I'm going to cut off further comment on this point.
Yeah, I was just trying to see about conversation between us regarding that extra provision in there that a veterinarian would be approving it before they'd be allowed to operate a shoeless. Can I quickly try to address about the 7 years versus 3 years and give some insight on some things I've seen? Some of these offenses that are listed here are actually misdemeanors. The domestic assault, domestic violence, a person could be convicted of that and receive it would be a Class A misdemeanor, carry up to 11 months, 29 days. Asking them to wait 7 years on a misdemeanor conviction before they could apply to be a driver of a horse-drawn carriage is too long. The other part in there, you look at leaving the scene of an accident. I believe that's still a misdemeanor. And again, the same problem. You got to wait 7 years after leaving the scene of an accident before you can apply to be a driver. Criminal solicitation or criminal attempt on any of these offenses, that's another level down below any of these. That's some of these ones that we've listed in here, 7 years is just unconscionable to make someone wait after a misdemeanor conviction to apply to be a driver. The Tennessee legislature established a 5-year period of time to apply for expungement of felonies, or certain targeted felonies, low-level felonies, Class E's that carry 1 to 6 years. After 5 years, some of those you can apply to the court for discretionary expungement of your offense. The legislature, in their wisdom, thought 5 years was appropriate there. I was looking at 3 years because I thought once someone has pled guilty, well, if they pled guilty to a homicide offense, they're not going to be out in 3 years. They're not going to be coming in before this commission in 3 years. If it's rape, they're not going to be coming before this commission in 3 years. Aggravated assault, they might be. I mean, it might, they might get a 3-year sentence, and at the end of their 3 years, they could be before us, because aggravated assault's a middle-level felony. It carries 3 to 6 years. Kidnapping, that's a more serious offense. They're not likely to be here in 3 years after their guilty plea, nor on robbery, possibly burglary. Some of these other offenses are not like any sex-related offense. There could be a sexual battery, which could typically you'll see a person plead guilty to sexual battery, get a 1-year sentence, 1-year probation. How long do you think they have to wait before they can apply for a job to be a driver on a horse-drawn carriage after that offense? So that's part of why I was saying 3 years, but make them come before us for us to look and make sure that we are comfortable with them. I'm open to 5 years if that seems to be right, but I would want to take out I would want to remove these misdemeanors and this criminal solicitation or criminal attempt to commit any of the above offenses if we were going to extend it out to 5 years. Someone pleads guilty to a small level felony possession or sale, distribution of narcotics. If you plead guilty to possession of marijuana for resale, you could get a 1-year sentence if it's a small quantity of marijuana. We're going to make them wait 5 years before they can apply to be a driver. I throw that out there.
I think it makes sense certainly to remove the misdemeanors or have them be in a separate section.
So I'm not opposed to talking about the various offenses and how the limitation might be different for the various offenses, but I would be opposed to reducing it for the felony charges, specifically the sex-related offenses. You might not be in front of us within 3 years of committing a homicide, but you certainly could be in front of us within 3 years of being released from incarceration for a homicide. So that's not really something that I support. I think that I'm always willing to talk about it. We could definitely talk about the misdemeanor aspect of it, but I disagree pretty strongly on the reducing the way it reads now with respect to the more serious violations. Respectfully.
So that would be to remove the domestic assault or domestic violence and the leaving the scene of an accident.
So, yeah, I mean, I don't know which ones are misdemeanor. Like, I assume you say leaving the scene of an accident is a misdemeanor?
Yes, those two are misdemeanors on here. What would makes it a little bit more complicated is criminal solicitation or criminal attempt could reduce some of these low-level felonies to misdemeanors. So.
Okay, I see what you're saying. So a criminal attempt to do, to commit a rape is different than a criminal attempt to, I don't know, sell some marijuana or something like that.
Tennessee has a graduated system of classifying offenses from E up to A regarding felonies, and criminal attempt can reduce it down one level. So a Class C could come down to a Class D, a Class D to an E, and an E would be reduced to a misdemeanor.
Okay.
Would you be open to reducing the 7 years down to 5 years?
Well, doesn't this ordinance govern? I mean, I'm looking at all vehicles for hire, including horse-drawn carriages. So is that what all is that including?
This language mirrors all the other ordinances that the Transportation and Licensing Commission has authority over. So this specific section you're looking at in Chapter 12, this is going to be only for the carriage industry. But if you were to open up if you were to look at the other sections, which will come before you, they're all going to say the same exact language.
And that's one of the things I had been talking to Mr. Fields that I would like to revisit over time, the other ordinances pertaining to to disqualification of applicants to drive cabs or slow speed vehicles or pedal vehicles, whatever.
And that was the reason I made the suggestion. If y'all have some specific language, this is as good a time as any from my perspective to go ahead and say this is what we believe the model should be. Assuming the council would agree with it, then we would turn around and ask to amend the other, the other chapters that you're responsible for.
Also, I'd mentioned that the concept of homicide includes a lot of different offenses, from starting worst, murder first degree, all the way down to criminally negligent homicide, which could be a car accident where someone was involved with extreme negligence and a death occurred.
And also what you're saying is that they would just be required to come before us, and then we can make a determination based on their testimony or whatever.
Correct. I'm looking to amend it to where a person's not immediately disqualified if they have one of these targeted offenses within the last whatever years,
But also not immediately qualified.
and they're not necessarily, no, they're not immediately qualified either. I'm sure Mr. Fields and his staff, in their discretion, like they do frequently with us, would bring him here and say, look, he's got a homicide. It was a murder second degree. Let's go with something in the middle. Murder second degree. He was released. He got a 15-year sentence. He was released after doing 85% of it, which would be, 13 years and something. And he was released 3 years ago. He's applied. I'm bringing him before you so you can question him. We get him up here. We find out the individual's been working as a chef at Shoney's. He's supporting his wife and his 2 children. This is a step up for him to get to do a side job, another job. And we say, okay, we find you're a qualified applicant. Or we get someone else who cops an attitude with us, or who's picked up other charges since he's been released. And we're like, this person's not qualified. Or we don't trust this person to be out there with the public. So I'm just wanting to reduce, or to change this, because I've been watching folks over the years up here. Someone gets convicted of a burglary. They broke in somebody's house. At the time, they were addicted to drugs and things. And so they were stealing, and I'm not saying it's right, I'm saying they were stealing to take stuff. And they get a 3-year sentence. And they've been out for 3 years now. They got released, and they've been out for 3 years, and they've been clean. They've been going to AA or NA, and they've been doing menial jobs. And they're coming up here before us now, and there's a record company here with them, and they want to apply to be a driver. And we get a chance to interview them and see if we think they're appropriate for that job or not. And I just remember the one young man there who was represented by Carl Dean at the Public Defender's Office. He had been out 5.5 or 6 years, and we had to tell him, and he'd had exemplary behavior, and we had to tell him, sorry, you got to wait another year to come back to us. And we would have approved him. I think we all agreed we would have approved him if he wasn't automatically disqualified. Now, if we could remove some of these misdemeanors and modify it maybe from 7 to 5 years, I think that would be a good start.
I understand. I'm good with. I'm better with the idea of having them come before us and then not being an automatic. Yeah. That. Thank you for clarifying that. That helped. Yeah.
And that is the way it works, right?
Absolutely.
Yeah.
If certain things are going to get them a trip, and you've made it clear domestic violence is something that you take very seriously. If it's a conviction of domestic violence, even if it's outside even if they might be eligible, they're going to probably have a visit with the commission, so you have an opportunity to talk about what happened. Any acts of violence, you're very concerned about that. You historically have been, so we continue to bring them to you. We definitely, as a staff, it's not our goal to disqualify. We like to say yes much more often than we get to say no, because no is not pleasant around the office. I'd be happy for y'all to come and watch no happen. But by the same token, I think guidance that you could recommend to the council that makes sense is good for us. Because again, here's a list, is a no-go list. This is a visit with a commission list. I think that's reasonable. It's a reasonable way to approach it.
And I was going to apologize for bringing this particular topic up here, without any forewarning or notice, but I realized I can't talk to anybody anyway other than Mr. Fields. So it's an opportunity for us to hold it in the public and have this discussion.
No, this is a good civics lesson, I think, for anyone who's watching. Mr. McNally, do you want to try to make a motion?
Are we ready?
Is there anyone who would like to make further comment regarding the proposed ordinance changes?
Can we go through those and clarify those one more time?
Sure.
Sorry.
Well, I don't know what Mr. McNally is going to propose.
Yeah, can I ask, what do folks feel about either passing this revised ordinance of Chapter 12.54 with some of the things we've discussed so far regarding qualifications, or are people thinking we need to defer on the 4 issues of temperature, gate, shoeing, and driver permit displays? I got the inclination that we were ready to go forward and make a decision.
I just want to. The reason I asked is I'm not 100% clear on what we're talking about. Temperature, we're leaving it the same.
If you remove, in other words, if it's removed from this proposal, the temperature that's in place is actually in a rule. It's rule number 4, and the horse carrier would stay the same. You have the authority in the current ordinance to change the rule next month if you choose to. We were just going to codify it and put it in the ordinance. But you have authority in the current ordinance as it stands today to set the temperature next month, February, March, April, May. You can revisit this without going to the council. So if you take it off today, then if you wanted to discuss it further, it would come back. I would be making a recommendation that you'd review the rule, and we'd propose. But you have the authority today, independent of the council, to establish the temperature. This would actually take away your authority to establish, and the council would establish.
So one thing we haven't discussed, but you did mention at the beginning of the public hearing, was the email from Elizabeth Howe. And she had a few suggestions to the ordinance. And I thought the first two were interesting, about the all working equine must be inspected and evaluated by a metro appointed veterinarian twice per year. And is that language in the current ordinance, Billy?
I'm sorry?
For her suggestion was all working equine must be inspected, evaluated by a metro appointed veterinarian twice per year.
It's not a metro appointed veterinarian.
It is a veterinarian.
Ordinance requires a vet visit, but not from metro. We're limited in the number of veterinarians that actually do equine in Nashville, as opposed to those that do all the other animals.
And then are those reports from those vets, are those sent to your office?
Mm-hmm. We'll be getting the next round beginning in about 2 weeks.
Okay. And then the two I thought was interesting as well, that all owners, operators, permit holders must pass a basic horsemanship test. And she explains it more, what her meaning was behind that in her attachment to the email. So I don't know if anybody else had any thoughts on those, and certainly if y'all wanted to look at those later, I'm open to that as well. I just didn't want to completely dismiss her letter to us.
I forgot about that, so I'm glad you brought that up.
The third thing about the trailing horses becoming hours that they're working.
Well, to answer your question, Mr. McNally, I'm getting the inclination from the commission that because we're considering making the proposed ordinance changes, recommending the proposed ordinance changes with the modifications that a lot of the members of the public and the horse carriage companies have brought to our attention, that it isn't really necessary to have continued deliberation on the proposal. Now, if there is a particular area that we do need to talk about that further, we can. But if we're making the recommendation with those changes, then I think we're addressing the vast majority of the concerns that the carriage companies have brought to our attention. Now, I realize there's quite a bit of a dispute between whether shoes or boots should be required or not, but we've also heard ad nauseum the arguments back and forth on that, so I'm not sure why we need to continue to deliberate that issue.
Okay. I'm pretty clear on the changes that I was recommending on section 14 regarding disqualifications of applicants, in section 4 where we remove or any employee. I heard seemed to be no objection to section 18 of a modification with specific expiration dates that was going to be changed on it by staff and legal. What other modifications are we looking at then in a motion that would need to be in a motion?
So you have one of the bigger ones was section 23, number 13, the trot rule.
And what's going to be?
Taking out the section unless the horse is pulling a carriage uphill.
Okay. 2313, okay.
And we have section 29, which is the temperature.
And 20, and then
Aren't we leaving the temperature at 90 and 35?
I'm just saying that was one of the sections in
Areas,
question.
yeah.
well, currently the temperature, I thought it was 25 and 95.
It is, your rule says 25, the Rule 4 says 25 and 95. If you delete, if you basically take 29 out, then it'll just remain the same until you, if you revisit it again, it will take you revisiting it, so.
And then the final.
So are we
additional-
recommending taking 29 out? Or leave it alone?
29 is
The temperature,
taking it out.
taking it out, good.
And then another change was section 27, subpart 1, removing the final sentence of that section 1, or part 1.
About no shoes?
Correct.
Okay.
So you eliminate beginning at if a certificate holder?
Yes.
Okay. All right.
And then
So that would leave it to where they'd be required to have tip shoes, bearing shoes, or shoes of some kind,
As it is today.
or a boot.
Yeah, it would basically make no change. But I mean, it's part of the section, we can leave it. Yeah.
Okay.
And then also, I need to be pointed to the section, but the section regarding the driver permit and the information that is required to be included.
13. Third page, I think.
There seemed to be a universal opinion from members of the public and the horse carriage companies that the required information should be limited to a photo, the person's name, the company that they work for, and perhaps we should implement a permit number system.
001 through 28. It'll be simple. I mean, as it stands today, we have 28.
That's going to be a lot easier for a person to remember.
I believe it. Ms. Stillman, it is still 28.
Section 13.
And what we would likely do is use the last four of the driver's license as the number. That way we'll just track it in the system with the last four of their driver's license, which is not revealing at all.
Okay. So the modification would be to section 13, part B, that such application shall be certified under oath and shall at a minimum contain the following information: the name, business address, actually,
What you're
I may
talking
be
about.
referring to the wrong section.
Well, actually,
Section 18.
Yeah, that's for the application.
That's the application?
yeah. So what you'd said earlier, would you do the
I think I gave
name,
you wrong on
the company, and a number?
Section 18, 1254, 144B. That's the last sentence.
Okay.
It doesn't even say B.
Right. So it seems like you can do it by regulation.
Mhm.
It's not even clear what you have to do anyway.
In the current ordinance, I think it is. I think we replaced it. In most of the applications, it allows the director that we design it and put the information on it, but we can do that.
Every driver displayed from on the clothing, we don't say what size it is.
Correct. So
Where are you looking?
I'm looking at section 18B.
Mm-hmm.
The sentence starts with every driver,
Conspicuously display.
but it
yeah.
doesn't mandate the size or the first name or the last name or anything like that. So it seems like it's an internal issue that.
I think there may be some language in the ordinance. I think we've done some replacement here. I think we can go and look, but I think that would give us your direction is what we would follow. We would reduce the size and require it worn with a lanyard.
All right, so no modification of 18B needs to be made. Just leave it up to discretion of the director.
Correct.
Okay.
And then that leaves the last item that you've raised, Mr. McDowell, which is section 14, part C, and coming up with language that addresses your points, and which I tend to agree with you after hearing your reasoning, which tends to just make the application process a little fair for those having been convicted and served their time and are wanting to get a job as a horse carriage driver.
Thank you. Okay, I'll make a motion to recommend to the council revisions of ordinance 12.54 pertaining to the Metropolitan Code of Laws, chapter 12.54, horse-drawn carriages, with the following revisions to the proposal before us today. Section 4, where it begins with the quotes, whether the applicant, I would recommend removing, or any employee, take that out of there. Section 27, subsection 1. Remove the very last sentence starting with, if a certificate holder wishes to work the horse without shoes, and then ending with the sentence ending there, horse-drawn carriage industry. Remove that entire sentence. Remove section 29 pertaining to the temperature, restrictions on the temperature that horses are permitted to operate. Section 23. In subsection 13, or identified section 13, that pertains to, have it read, not permit the speed at which any horse-drawn carriage is driven to exceed a trot, period. Remove the language unless the horse is pulling a carriage uphill, and, or leave the and. Section 18, permit the TLC staff and Metro Legal to set specific, to modify it to set specific expiration dates. Does that cover your wish?
Mm-hmm.
Just
okay.
yes.
Now, section 14, regarding criminal background investigation and disqualified applicants. That's section 14C, subsection 1. Have it read, has been convicted, comma, pled guilty, comma, nolo contendere, comma, and then remove, placed on judicial diversion pursuant to Tennessee Code annotated section 40-35-3013, or been released from incarceration, probation, or parole, and just have it read, has been convicted, pled guilty, nolo contendere, within a period of 3 years prior to the date of the application. Then going down, I would also move to remove domestic assault and domestic violence as a targeted offense, and remove leaving the scene of an accident as a targeted offense. And that the director and the staff of TLC understands that this commission wants anyone who is a qualified applicant and has any of these in their criminal background check, that they will appear before this commission before a permit is issued.
Okay.
Okay. That doesn't have to be part of the revision. The revision's just as much. Does that cover everything?
Yes, you can ask a question.
I just once again need clarification of what the temperature is going to say if we leave out what it says now.
Correct.
A range of 25 degrees to 95 degrees.
Okay. That was my question. Thank you.
Has everyone had a chance to consider the motion? Is there a second?
I'll second.
All those in favor?
Aye.
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 Do we have an aye down at the end?
Oh, I did. Yes,
All
aye.
right, motion passes. Mr. Fields, it's almost 4 o'clock. I'd like to take some of these applications down at the bottom, maybe out of order, just so we make sure we cover them.
Okay.
We've been asked for a few requests by Yellow Cab to alter the age limitation for vehicles.
Is there a representative from Yellow Cab? Come on up, Henry. Yellow Cab made a request that you reconsider, and again, it's not a public hearing, but but you would consider the age limit. Presently, the age limit is 10 years that a taxi cab can operate. We just changed that year before last, and they have a specific request. When the companies have requests, we typically try to bring them in front of you for you to hear them directly, and if you have any actions. As I told Henry, I was not necessarily, well, I'll let him speak, then I'll tell you what I thought.
My name is Henry Brandon, Yellow Cab. No position. I drive, dispatch, do what I need to do. Okay. I'll make this brief. Really have one comment and 3 main points. Get into the discussion. I've personally seen several taxis pulled from the fleet after the 10-year expiration date that would have made it through inspection. May have needed some tweaks, but they didn't even try because they're almost like they're milk. They're through. They're gone. Okay. The thing is, I hear a lot of the old drivers talk about how they don't make cars the way they used to, and they don't. The Caprice, the town car, that was great luxury. Crown Victoria, wonderful cars, handled well, beautifully. Easy to work on, park it under a shade tree, fix it up. The problem is you were always working on those. Every 2 or 3 times a month they were breaking down. As they got older, once or twice a week. Now, it's 21st century, these cars are built to last. They're made better than they used to be made. They're safer, cost more to repair, but nonetheless, you get what you pay for. Okay, with the onslaught of the minimally regulated services we have, Uber, Lyft, scooters, golf carts, bikes, I don't know. Anyway, the really bad drivers and their bad vehicles are gone. You cannot make it in this industry now unless you care about your passengers and by extension care about your vehicle and yourself. Drivers, for the most part, we have a few squirrels running around, but they don't last long. The drivers that make it now, it's not a job, it's a way of life. They care about it. They feel almost like social paramedics. I mean, they love what they do. I mean, they're trying to pay their bills, but their vehicle, they put money aside every week. My formula is $75 a week, okay? For when, not if, but when something breaks down, when you need a new fuel pump, water pump, radiator, transmission, engine, they're going to wear down, okay? They're going to go, okay? Repainting, reupholstery, take care of the headliner, do what you have to do. Okay, the inspectors you have now, they don't play. They're serious. They take their job very seriously. I miss Buddy Lawhorn, but these folks, they do it well. Okay, so for sake of illustration, okay, and I'll pretty much end with this. If you have a 2000, okay, right now, before a vehicle, the oldest a vehicle can be, before it can be put on the line as a taxi, is 7 years old. It used to be 5 years. It's been extended 2 years. What I'm asking for is the expiration date to be extended another 2 years. Not for the new cab, but for existing cabs. It's a little complicated. Okay, a 2013 year model vehicle, that's the oldest you could put on the line right now, do I get it, would expire in 2023. 2019, it would have been in service for 3 years. A 2019 year model, nobody ever buys a current model year vehicle for a cab just for the sake of the depreciation, the loss in depreciation, but the sake of illustration, a 2019 year model vehicle would expire in 2029, January the 1st. My experience has been the average taxi driver in Nashville who does it for a living, day in and day out, averages about 75,000 miles a year in driving. That's not billable miles, it's just what they put on their vehicle. Driving a vehicle as a cab or a taxi is hard on the vehicle. The 2019 year model vehicle at the end of its 10 years would have put in, for sake of illustration, 750,000 miles. You can bet they will have replaced the drivetrain, the engine, God knows what, maybe several times before it comes up and has to be pulled off the line. And it would have had to have passed inspection. Let me get my little arithmetic here. The 2013 year model, after 3 years, would have had 425,000 miles on it, but if we extended it another 2 years, would have been in service for 5 years, we would have had 575,000 miles on it. Still a lot of miles, probably would have had to make some maintenance and repairs on the way. So I really don't see why we can't extend the limit that a vehicle can be, before it can be pulled off the line, by another 2 years, just like we extended the limit for a vehicle to be put on the line. Cars are better made now. It has to pass inspection. I mean, you can't just keep it, okay? So if it can pass inspection, why not give it the other 2 years? The only argument I can feel that I could come up with, if you've got others, let me know. The only objection I can think of would be, well, you want 2 years, why stop there? Why not go 5, 10? Well, you know, look, you have to stop at some point. I admit, sooner or later, a vehicle starts to look kind of quaint. One of my personal vehicles is a 1999 Crown Victoria. I would never use it as a cab. It looks like Grandpa's car. It's got 29,000 miles on it. Okay? It's great. I bought it 6 months ago with 26,000 miles on it. It was literally owned by a little old lady, or elderly lady, used it to go to church and to the store, I swear. But it doesn't look like, you can't have it as a cab. We do need rules and regulations, and after a model is 12 years old, probably does need to go because they've made improvements and it just looks old. But 2 years, I don't see where that makes a big difference. And like I said, what really prompted me was seeing several vehicles that likely would have made it through inspection pulled because, oops, year's up, that's it. Anyway, that's what I'm asking.
Any questions? Thank you very much.
Okay, thank you.
Mr. Fields, do we need to take up any issue? Or?
I think it's an issue the commission can choose to take up or not take up. I appreciate Henry Brand. He's one of the conscientious drivers, and I'll say that I've known him for years, and there's no question he is conscientious, and he represents the industry well and is well spoken. I think there probably are exceptions of cabs that might be able to pass inspection. I think part of the history, though, is we used to take them off at 9 years. A couple of years ago, we were able to change that to go to a full 10 years because there was always confusion. So a 2000, if you put on a vehicle today, you would get a full 10 years out of it. Then historically, you would only get 9. I think the actual mileage, we can certainly explore it, and I can ask inspectors to do some checking. Inspector Morris is here. I could be happy to invite him up, or if you wanted to hear from him today, I would. Again, they see cabs more often. Typically, a cab that's 10 years old, I think Henry, they're not road. They may be roadworthy, but they're not cab worthy. But it's your option we could certainly. Review it. We could ask for some reports from the commission. We can from the inspectors. We can ask for reports from the actual companies and say, tell us about your cabs. Show me all of your 2009s because they're going to be coming off at the end of this year. Tell me how many miles they have, and we could certainly do some checking to give a fair hearing to the request. Again, fairness is I think fairness is always important, and I certainly don't want to dismiss somebody's thoughts or ideas if it, in terms of maybe having a review of it.
Commissioners?
I'm open to hearing some input from the cab companies about why it should be extended 2 years. I hadn't thought about the fact that you have a cab that is road worthy, will pass inspection, but what about the aesthetic value of it in terms of the people who visit our city? Until Mr. Brandon was speaking about it today. Yeah. I was thinking that the most important thing to me is that the public is safe in this vehicle, and we set a number of years for the operation of the vehicle with the idea that promoted public safety.
And that's what we would be looking at.
Yeah.
So we would, if you don't commit me to bringing it back as quickly as we can, we'll be glad to do a study. We'll also review some other cities, and we'll ask for some input from the companies in terms of some reviews of the mileage and so forth. I'll ask the inspectors to participate in that process.
Because I had thought at first maybe we ought to be looking at the amount of mileage on a vehicle, but that's not going to tell us. When you're talking in terms of 500,000 or 750,000 miles, it doesn't tell me much as far as the safety of the vehicle.
Well,
can you put it out to the owners of the cab companies that we'd like some input on this and their thoughts? And
we can do it.
And maybe the inspectors come tell us what these vehicles look like after 10 years of use. And then we'll look at what other cities do as well.
Yes, sir.
Thank you, Mr. Fields.
Okay.
Next item is under record and towing services. We've been asked to review the driver application of Eduardo Avendano and Roy D. Porter. Mr. Fields.
We're going to call Mr. Avendano up first.
Yes.
Eduardo Avendano. In making his application, he actually revealed a great deal. However, he had some driving, just actual driver's license issues that he revealed to us in terms of driving without license, driving a revoked license, had other issues. So we brought him for your review. Again, I think he probably qualifies. I think he's one of those that I think y'all would probably want to at least visit with a few minutes. And his most serious charges would have been several years ago.
What was the March 2018 reckless endangerment? What was that about?
I got in a car accident, and I hit a pole.
Mr. Avendano, have you had any driving issues, any tickets, anything since 2013 where you were charged with driving on a revoked license?
No, sir.
You know, the offense on March 18th, 2008, that's the one that you were convicted of reckless endangerment?
Yes, sir.
What were you initially charged with?
That
That's
was the charge.
March 2018. Is that what you said?
Yeah, March
2008?
I'm sorry, March 8th, 2018.
Yeah.
That's one where you hit a pole.
Yes, sir.
And you were given, it looks like you were given a citation?
Not quite sure. I mean, what do you mean by that? All I know, I woke up in a
Were
hospital.
you arrested, taken in jail in handcuffs?
No, no.
Oh, you were injured, probably.
I was injured. I broke
Yeah,
both of my
taken
knees.
to a hospital?
Yeah, I broke both of my knees.
And they wrote you a citation?
Yeah.
And you're telling me today, in front of this commission, that you were just charged with reckless endangerment?
That's the charge that I received. Yes.
Well, what about the DUI charge?
No, that
Driving
was
under the influence.
That was a lesser. They dropped that to a reckless endangerment.
That's my first question. What were you charged with?
Oh, yeah, that was DUI.
Yes.
Right.
So
I
you were
thought-
in an accident, taken to a hospital, and charged with driving under the influence.
Right. Right. Yes, sir.
And then you went to court and was reduced to reckless endangerment.
Correct.
What was your blood or breath alcohol level?
There was none. There was none taken. No blood. Blood or breathalyzer.
When I asked you what you were charged with, why didn't you tell me DUI?
I didn't understand the question.
What was the felony that was dismissed in 2010?
That was fugitive for child support. My case is based out in Kentucky. My baby mama at the time, she sent it to the wrong address, and I missed the court. As soon as that was clarified, they just dropped the charge. But she did that on purpose, knowing that I didn't live there. So once I went to court and showed proof that I haven't lived there for X amount of years, they dropped it. And ever since then, I went to 2 months ago. I went to the courthouse across the street and got everything expunged. It's in the process. I got proof of it, of that. Also with the tickets and that I have gotten as total 8 things are in the process of being expunged as we speak.
And when you were arrested for, or when you were charged with driving under the influence, given the citation, and you pled guilty to reckless endangerment,
Yes.
what else did you plead guilty to?
That was it?
Didn't you plead guilty to implied consent?
I don't know what that means.
You were also charged in SCE 261687 at the same time of the DUI with violation of implied consent law, that you didn't give a breath or blood alcohol.
Well, see what happened. I mean, I don't remember the accident at all. I was pinned down, conscious. I woke up the first time in the operating room, and I don't have no recollection at all of what happened.
When you pled guilty to the reckless endangerment, did you also lose your driver's license privileges?
No, sir.
So you're saying you did not plead guilty to implied violation of
No, I
implied
still
consent
have
law?
my license and everything, sir. I currently work for a company that requires me to, I drive a company's truck, and they require for me to have that. Otherwise, I wouldn't have my job.
The Tennessee Bureau of Investigation's report that was criminal background check on you indicates that you were convicted of the offense of violation of implied consent law.
Don't know. I mean, that would mean my license would have got suspended, correct?
Yes, it does. Yes,
Yeah.
that's right. That's why I was asking.
Yeah, no, I can show them to you right here. I even got my F endorsement. That's where I'm here today.
Okay. Yeah. Say what? 11 months, 29 days, just about. Yeah. You're off probation from that reckless endangerment?
No.
You're
Next,
still on probation?
Yeah.
Okay.
Well, when I go to court next 3 weeks is when I get off supervision. February 14th, 15th.
February 14th, yeah.
That's what it is, yeah. That's when I go back to court.
I guess reckless endangerment was not one of our targeted offenses
Well, they actually, the record drivers have a different set of standards.
Yeah, that's what I was
That's the
wondering, yeah.
last one that we're trying to bring into into where we've, across the board, this is what is required.
I just want to make sure I understand. When you said, did you say that there wasn't a blood alcohol reading?
No, there was no breathalyzer or alcohol. I mean, either one. I know there's two of them. They can do on yourself, right? But neither one was done.
Is that because you refused to let them, or
No, they was just not one done. To be honest, to this day, I have no idea why. And I was, like I said, I was pinned down. I don't have no recollection of the accident at all. I know I was pinned down for like an hour. You know, I woke up when they were operating on me. They put me back to sleep. I woke up, you know, a day later. And yeah, that's all I know.
So you're probably unable to consent or not, or decline the blood and breath alcohol test.
Well, there was people saying I was screaming and, you know, pain and all, you know, that came with it.
Yeah.
I just don't have no recollection of the accident.
Like, the main thing that brought you here was these numerous driving without a license.
Yeah.
Over, in 2005, it looks like there were at least 3 there, and then in 2008, another 2, and what's the deal to drive without a license in the past?
Child support. Child support played a big role. You know, being backed up on child support, it played a huge role, to be honest. Getting everything together, getting paid. You know, back in those days, I wouldn't get paid a lot, so it's really hard.
So you were behind in child support, and they revoked your driving privileges as a result of that, and then you would drive.
At one point, yeah, yes, sir. I still had.
You were the one who decided to drive, right?
Yes, sir.
Okay.
Yeah. I had to get to work somehow. Otherwise, you know, they'll put you in jail if you don't go to work for, you know.
Who's offering you a job?
Collins.
And are they here?
No, they said that we're gonna submit some paper on their behalf.
Mr. Fields, if Mr. Abendano had pled guilty to a DUI in March 2018 for an offense dated September 2017, would he be qualified as an applicant?
If you have if you're 3 years, it'd take 3 years to get the DUI off if no one was injured. To make it where it would be eligible, it would be 5 if someone was injured in an accident. So had he been guilty, he would not be eligible today.
Well, Mr. Abendano, as you can see, the commission is reluctant to grant your application given your recent offense here, even though it was pled to a lesser offense of reckless endangerment, it still involved driving under the influence.
Okay.
As well as the collateral charge of refusing to consent to a breathalyzer or a blood test.
Did the court place any conditions on your sentence? Anything that you were required to do?
Yeah.
when you pled?
In order for me to keep my license on touch, my lawyer requested to see if I can get a alcohol monitor put on my knee, which I have right now.
The ignition device?
No, not ignition. Ankle.
What is it? Oh, an ankle.
Ankle
okay.
bracelet. Yeah. And at first, I had to attend drug on-call random drug testing, and then some classes. I completed everything that's required of me to.
It's one of your conditions that you have to stay away from alcohol for the period of probation?
Yes, sir.
Is that why you have the ankle monitor?
Yes, sir. That way they won't, my license won't be touched.
Okay. Now, have you had any violations of probation over the last 11 months?
No, not at all. Not at all.
You haven't been back in front of Judge Blackburn?
No. And next month I will.
Yes.
Yeah. And that's it. No, not at all. I got 5 kids. Now things have changed. I had my baby New Year's Eve. So no sleep, but things have changed. I have definitely grown. I know the difference of
You get a tax
maintaining a
deduction
license.
for 2018.
Huh?
You get a tax deduction for 2018.
The doctor, as soon as she came out, that was the first thing he said. We're still waiting on the social.
What if we were to hold your application in abeyance and see till after you're off probation, and a couple more months from now you come back here and you can report to us that you haven't been drinking or anything?
That would be great.
Would they hold your job for you? Do you know?
Oh, I don't know. Don't know, to be honest. They've been waiting for me for the last month because the committee.
Mm-hmm.
It wouldn't take place until today, so actually a little over a month now. So
we're able to put him on TLC, super duper probation, aren't we?
Yes, sir. You can certainly offer him a permit. There's no such thing as a temporary permit. What you can do is give him a permit. Requires attendance at a commission meeting in a certain amount of time.
But we have no way of monitoring whether he's drinking or not, do we?
Well, we can, if you choose to, as a condition, you can require him to have random testing. You could require the company to be responsible for that random testing process and report back to us. You could then also require as many random tests as you think is sufficient, whether it's weekly or 2 between now and March the 23rd.
I'll be more than happy to do whatever you guys need to. I have no problems with that at all.
I hate not giving a person with 5 kids and one just born not an opportunity to work if he's got an opportunity
She's number
to work.
5.
Say what?
She's number 5.
Okay. On the other hand, operating a tow truck record service is serious business. I mean, you're out there with the public usually when they're not in their best mood.
I agree. Well, as right now, I work pest control, and I'm always out. Of course, like what you just mentioned is not, in their best moments, but nonetheless, there are pretty upset people out there. So, that's definitely a challenge I can take. Just unfortunately, doesn't pay the bills.
Mr. Fields, you know the owner of Cotton fairly well, don't you?
The way Mr. Williams, David's the day-to-day manager.
Miss Williams?
David Williams,
David
Doug Williams, the
yeah.
owner, David Williams, the manager.
I would make a motion to approve Mr. Avendano's application with the condition that over the next 6 months there'd be bi-weekly alcohol testing, that Mr. Fields communicate to Doug Williams that this gentleman be monitored carefully for alcohol use. and that there be something reported back to Mr. Fields at the end of the 6 months. And if there's no problems, then nothing further needs to come before this commission. If there are problems, I'd like to bring them back to review that permit. I would also amend that or add an addendum to that motion that if any alcohol use while employed is noted to Mr. Fields, that he be authorized to immediately pull the permit.
I'm happy to second that if that means we can do it.
All those in favor?
Aye.
Any opposed?
No.
Motion passes. Congratulations, Mr. Avenatti.
Thank you, guys. I do appreciate it for giving me the chance. You guys won't regret it. Thank you.
And next is we have an applicant for record and towing services by Roy Porter.
Mr. Porter? Roy Porter. Mr. Porter does not appear to be present. Roy Porter?
What was the problem?
He failed to disclose in 1997 contributing to the delinquency of a minor.
Any idea how old he was in 1997?
Well, he was born in 78, so it would have been 19.
19.
Is that right?
Yeah, because I was just buddy in 1970.
We have expert testimony on his age.
We have no indication why Mr. Porter's not here. I make a motion to...
He probably
Died?
That's a joke.
Oh.
Waiting.
Ms. Stillman says we think he was present. He may have left.
I make a motion to defer to the next meeting.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a driver application for an other passenger vehicle for hire by Paul Gajot, or Gajo. Mr. Gajo.
In making his application, he failed to list an assault and battery which occurred in December.
Well, the application's dated December 7th, right?
Correct.
It
wasn't last year.
Wait just a minute. Wait 1 second. I apologize. He failed to list the assault and battery. That was not the day.
That's when I made the application.
Yeah, he failed to list the assault and battery was actually back in 2001. I apologize. I was reading from the wrong line. Other than that, he would be qualified. He did have some other charges, but none that would disqualify.
Is there a reason you failed to list it?
I had my son with me in the trailer where we do the application, and he was acting up and crying, and I just was kind of frazzled and forgot it. It's been almost 20 years. It slipped my mind.
I wasn't present, but there's occasional frazzling in my office.
It's a tight space.
Anytime. Is this the baby back here?
Yes, he
Yeah,
slept
I
through most of
understand.
this.
I understand. He's been very good.
So did I.
He's got a QT orange on. Just-
We've never called a baby, but I bet we can get him up here. So.
He's ready to go to the game tonight.
So what's the nature of the assault charge?
Excuse me?
What is the nature of the assault charge and conviction?
There was no conviction.
No conviction?
No.
Just charged?
Yes, sir.
What were you charged with doing?
I was charged with hitting my girlfriend at the time.
Why was there no conviction?
She didn't show up in court.
commissioners like to make a motion or have any further questions?
I make a motion to approve Mr. Gojo's application.
I'll second that.
All those in favor?
Aye.
Any opposed? Motion passes. Next, we have a driver
you.
application. Thank you. For an other passenger vehicle for hire by Tamara Larkin.
Ms. Larkin? Would you come forward, please? In making her application, she failed to list two charges in 2005, a marijuana possession and a drug paraphernalia charge. Otherwise, she appears to be qualified.
Why did you fail to list those charges?
I honestly forgot. It had been so long.
What is improper discharge of passenger?
That's where I didn't have control of someone else getting out of my vehicle. They just got out of the vehicle. If I'd locked the door, I'd have kind of been holding them hostage. So they just clearly got out of my vehicle before I was able to get to the appropriate place to stop.
Okay, can you help me a second? I'm trying to read through the criminal background report here, but I think it'd be quicker if I could just ask you these questions. The March 1999 assault case, were you found guilty or not guilty?
Honestly, I don't remember.
Okay. And then there's number 8 here on your list, March 25th. Maybe it's the same thing. March 25th, 1999, citation date June 26, 2000, assault bodily injury. And it lists 2 warrant numbers. One of them's the same one as the March 99 one I just referred to.
Right, I was confused by all that. I wasn't for sure, because I couldn't remember, so I went.
Did you have 2 assault cases or 1?
I had 1.
1?
Yeah.
Why do you have 2 numbers down there then?
I don't know. I can't answer that.
Well, where'd you get those numbers?
I got them off. I had a police report filed because I was trying
Yeah.
to make sure I had this as accurate as possible before turning this in. And so I was kind of going by that, even though I really couldn't understand the way that it was worded and put. I was just trying to make sure I had my application as,
And then the December 2014 reckless endangerment. That's generally a serious charge. What's that about, and what was the disposition?
I did probation for 1129.
Mm-hmm. What were the underlying facts of that charge?
I'm sorry?
What were the facts that supported the reckless endangerment charge?
I'm not sure I understand.
What'd you do?
Well, originally it was a DUI charge, and then it was reduced to reckless endangerment.
So you charged with driving under the influence, and through plea bargaining was reduced to reckless endangerment at 1129. Did you get off probation okay?
Yes, sir. Oh, yeah.
Who are you going to work for?
Luxury Ride Nashville.
Looks like you got your license back in March of 2018. Is that right?
Yes, I believe so, yes.
And since then, you had just the one ticket?
I believe so, yes. Yeah.
Failure to merge?
Uh-huh.
And other than failing to list the 2001, was it?
She would be qualified.
I motion to approve if she otherwise qualifies.
All those in favor?
Aye.
Aye.
Motion passes.
Thank
you.
Who made the second? I'm sorry. Oh, okay, I'm sorry. Thank you.
Next, we've been asked to review Go Livery's request to change their name to Ovision LLC, doing business as Go Livery.
It's a simple name change in order for them to be able to make the change because on the face of their application they would have to. So it's a simple process. Nothing else is changing.
Move to approve.
Second.
All those in favor?
Aye.
Aye.
Motion passes. We also have 2 company applications for other passenger vehicles to hire. The first is from Nahome's Ride, and the second is Noel Limousine.
Same thing. In order for them to operate as other passenger vehicles for hire, it takes the commission's approval. Their application was ordered. They file all the appropriate documentation.
Motion to approve.
Second.
All those in favor?
Aye.
Motion passes. Next, it's under SUMDs. We've been asked to review the SUMD pilot expansion process for Bird and Lime. Mr. Fields?
Let me make an explanation if I can. When the Metro Council established the pilot program, it requires certain things to be met prior to the companies expanding. So they can start with 500. In order to go to 250 after 1 month, they have to meet 3 standards. To go to 1,000 after another month, they have to meet another standard. If they, as the ordinance is written, if they meet the standard, then they would be able to move forward. In this particular case, there was, since it was the first time, there were clarity issues and a little bit of confusion from the standpoint of how they would move forward. Since then, we've developed a process by which they would expand by coming to the licensing commission and showing if each vehicle has met the standard, which means they average 3 rides per day, that they are below the threshold that the commission established for company complaints, and that the third standard is they have to be working toward compliance and be in compliance with 1262, which established the pilot program. At the time, both companies brought information to me that indicated that they would pass that standard. At that point, it broke down. They expanded. At this point, we're asking in advance for them to be able to have expanded. And again, had they been present and presented, you would have. And it's more or less an automatic approval. If they do this, and if they do that, and if they do the other, then they're eligible. Now, to go above 1,000, to go to 1,001, then they have to come back in front of the commission and actually begin a different kind of a process to show a need and other kind of standards which are very similar to taxi cabs. Did I sum that up pretty well?
I can read the exact language. Each expansion or increase in fleet size shall require a determination by the MTLC or its staff that A, the permitted operator has fulfilled the requirements of this chapter, B, the number of violations associated with the SUMDs or that operator is below a threshold to be established by the MTLC, and that's the one that required further explanation that we've worked on recently, and C, the type or category of SUMD in the permitted operator's current fleet to be increased is meeting or exceeding the average utilization threshold, which for scooters is 3 trips per day. Going back to B, which required a little more explanation, The two issues that we clarified were what is the threshold, and you all established that that threshold was 20 violations per year, which can be prorated to a monthly basis, which would be a little less than 2 per month. And then we defined violation at the last meeting. That was in the minutes that you just approved. It's a long and complicated definition, so I'll sum it up a little bit. The first concept is that to be evidentiary support for a violation unless it comes from a member of the TLC staff, Public Works staff, or MMPD. The second is kind of two-pronged, that a violation will only count against a certificate holder if A, there's some evidence that can be attributed directly to the certificate holder. And the examples were like putting out scooters improperly in the morning, or failing to respond within a 2-hour time frame when they're notified to move a scooter that's improperly parked. Or B, if you have, and you pick the number 25 per month, documented violations by users of the scooters, and we can be sure that those are of one particular company's scooters, then those can be attributed to the company if it's over 25 per month as a violation of their obligation to inform, regularly educate, and instruct their users to comply with the law.
I've reviewed documentation that both companies have provided that would have covered the period in which we would be talking about, which would have been their first 2 months. Based on the review, I think they are within compliance and have met those standards that have to be met. They are present. If you'd like to hear from them directly, they're here. A representative from each company is here.
Is there any action that we need to take right now?
I think it'd be appropriate to approve it. That way, and then in the future, prior to a company's expansion, and we have no request for expansion at the present time, we would require them to present information and be available for your review here at the commission.
Bird and Lime already expanded, though.
Correct.
Without permission. Without approval.
Correct. Again, it was our first run. This is me certainly not defending anyone that would overstep a bound, but y'all know I'm.
So it's asking us to approve something that they've already done.
So they took a different interpretation of the code provision than we did. I was reading to you from 1262-0804. 1262-0802 says each type of category of SUMD in a permitted operator's fleet shall be limited in number to 500 for each category of the shared vehicle during the first month, 750 during the second month, and 1,000 beginning in the third month. So they interpreted that provision that 4 did not apply to 2. We disagreed with that interpretation, and so knowing that we disagreed with it, they still chose to go with their interpretation and go ahead and expand to 1,000 without getting your permission first. However, if you find that they are otherwise qualified for it, we would like you to go ahead and make a finding about that, because we want to set a precedent that with those types of expansions, this finding does need to be made by the commission, and better to make it late than never.
However, we were here in the public, right here in this meeting last time, and we were having that discussion with them that there was a different interpretation of that particular provision. Metro Legal and the commission took the position they needed to come to us first for the approval before they expanded. And they voiced their opinion that they thought they could expand without our prior approval.
They did prior to coming to the commission.
Yeah.
In other words, we knew in December, at that point we knew we were going to be bringing them to you in January for this review.
And the dispute or the difference of opinion of interpretation of that provision was discussed right here in this room, and they still went ahead and did it.
Well, that was after they had expanded.
Yeah, it was prior. The expansion was back in probably late October, early November.
Right.
So they did not have that guidance at that particular moment. They had the guidance, and that's the reason they're here prepared for your actions. And again, my issue is almost always compliance issues. So we want to make sure that it can't happen again. So by reviewing it, again, they haven't met the standard, they're here, and they'd be glad to share it. But I've reviewed it. We're also working with IT, with Metro Information Services. So we're going to be able to independently present evidence as well through various dashboards and other material that we're in the process of developing the analytics in order to study it.
Why does this feel like a deja vu of Uber and Lyft again? Ask for permission. Go ahead and do it, and then ask for permission.
And not an effort to defend, but an effort to explain. I think at the same time then, not exactly the same, but some of the same, it was an issue. It was the first time, and in trying to make sure we were getting it right. And again, I'll take whatever credit I need to take for, I'm not sure how I might have stopped it, but by the same token, I think we're all on the same page today.
And Mr. Fields, I'm not pointing a finger towards you at all.
Oh, I understand. I didn't accept. I just, we're just trying to make sure that we go forward with all on the same page.
And as a further clarification, there is a bill pending before the council. It has many different amendments to this chapter of the code that are proposed. I believe it was deferred. Is that right?
It was deferred
It was deferred at the last council meeting.
And there will be additional amendments. There were 10 or 11. I think there are going to be more.
But one of the amendments in the last revision of that was to make it explicitly clear in 1262-080 that 4, which may be here referred to as D, there is some confusion about whether it's 4 or D, is applicable to 2 or B of 1262-080. So they went in and clarified that in the proposed amendment just so it would be crystal clear. The council sponsor did.
Because there was enough confusion, they wanted to make sure, and the legislation basically accepted the policy that we developed with Metro Legal on the way forward on any expansions.
This might not matter, but I'm curious. When you talked about the violations, you said they can't have more than 25 a month by users?
So yes. So I could. It's actually in your minutes. I think it was maybe the second or third page of your minute packet. And then it says violation definition explanation for 1262-080-4B. If you have a copy of the minute, I have a copy of it right here. You can have if you want.
And that was so that was one of the things they had to meet in order to get through.
So they have to meet 3 things, and B was confusing. The number of violations associated with the SUMDs, which is shared urban mobility devices, that of that operator is below a threshold to be established by the MTLC. So the first thing we did was establish, or the first thing you all did, was to establish that threshold, and that was 20 per year. But then we got into a discussion of what is a violation, and we realized that needed a lot more clarification. And so that definition that's in those minutes is what was passed by the TLC last month at their meeting. And, we made it pretty involved and careful. We were trying to be fair, to give some due process, to allow them to respond especially to the allegations of violations by the users, without making it unduly burdensome on staff and or MNPD to establish that the violations occurred when they really did. So we were trying to find that balance in that definition, and hopefully we succeeded.
I'm just curious how they met it, since I witness about 7 or 8 a day.
Well, part of it is their particular expansion would have been September, October. The first standard wasn't established to November, and the second standard wasn't established to December. Yeah. So for future, they would be able to do that. But again, and it may be simpler because again we're running short on time. We still have some issues to deal with. We'll set up a meeting to go through that to explain how we got to where we needed to. Okay. Very happy to do that with Ms. Costonas.
Sure.
I take it that the council is considering revised changes to its ordinance. Is this for after the pilot program is concluded, or?
At the present, I mean, unless I'm misunderstanding, it's for the pilot as it stands. Your staff has been directed to develop a study that will be presented at to the Metro Council in July that will, assuming that we go forward I think we will actually be making some recommendations specifically on the future of this particular ordinance.
I mean, I believe that these clarifications were brought directly by the sponsor.
Correct. To the pilot. So the pilot sponsor brought them. There may be some more amendments.
Like requiring helmets.
It certainly could be something he brings.
All right. I think I understand the issue. I do think we need to clarify for the SUMD companies that they do need to seek approval from the commission before they expand.
At the present time, from a staffing standpoint and a permitting standpoint, they cannot expand without coming back to the commission. Right. Their certificate does not bear more than 500 as it stands. Anything above that would be a violation of the companies that came past the first two.
Do we need to? Does someone need to make a motion, or do we just need to make that clear on the record?
Ms. Costello, should they just go ahead and make a motion?
The only way the commission can act is through a motion.
Okay.
What are we acting on? Approval of their expansion?
It's a question
Well,
of
the
making a
interpretation of the
finding
rule.
of whether they have complied with the three criteria in 1262-0804 that they are that the permitted operator has fulfilled the requirements of this chapter. The number of violations associated with the SUMDs of that operator is below a threshold to be established by the MTLC, and that the type or category of SUMD in the permitted operator's current fleet to be increased is meeting or exceeding the average utilization threshold, which again,
And the
it says further down is 3 per.
The evidence that
day.
they have complied with 1262-080 is...
I've reviewed it. They're both here, and we'd
Mr.
be glad
Fields
to
telling
present
us.
it. But they both have exceeded the number of average rides per vehicle.
I just want
Okay.
to know it's
Correct.
You've
Yes.
reviewed it. You've approved it.
Yes.
Okay. I make a motion to find that Bird and Lime have complied with section 12.62.080.
4.
4.
That's okay.
I'm going to leave it at that.
All those in favor?
Aye.
Motion passes. Mr. Fields, we've got 4 minutes to 5 according to my phone here. I know we have a number of complaints also on the agenda.
I could never predict how long a hearing for a complaint might take. What I can tell you is there are some complaints that have some common issues in terms of, the first one is against an individual. The second series are going to be against a company that again I think is basic information. The next one is going to be again against a company involving some of the same issues of signage, question of a permitted driver, and so forth. Then, I think you could take a shot at them. We're good till about 5:30 if y'all are good to it. Again, if we could dispose of them, it'd be great. But we've got one taxi cab complaint is brought by staff.
Well, commissioners, are you able to go past 5 today? I can go until about 5:15, so I seriously doubt we can complete all of the complaints. So some of these are going to get rolled over to the next meeting. Is there, Mr. Fields, is there a recommended
Well, if
one we should take up?
if we're going to have to roll, I mean, it would make sense. I mean, I hate to do this, but it makes sense to keep the carriage complaints together, and they take the one taxi cab driver out, because again, it is one. It's just one. The others, they're not all interconnected, but there's a lot of connection between. You're going to have complaints. You'll have 3 different complaints from Nashville National Animal Advocacy. You've got complaints by American Melody. You've got complaints by.
Let's take up the complaint by that Mr. Morris has brought against Hasim Wakamo, excuse me, and I mean, even staying until 5:30, I don't see how we're going to get through all of the carriage complaints. So let's hear from Mr. Morris.
Mr.
Chairman, obviously I'm here for the very Sugar Creek matters. Would I be excused at this point? Given what you just said?
Yes, sir. And I apologize. We try to get through as much as we can in the afternoon, and even stay until 5:20, 5:30.
Thank you.
All right.
Mr. Inspector Morris, Mr. Wakamo, both present. I hope.
You cleared the house. Except for
Yeah.
Herman's still Bill?
The inspector and Mr. Wakamo.
Thank you.
And for the record, Attorney John Ballard for Mr. Walker.
Thank you, Mr. Ballard.
Thank you for seeing us.
Mr. Morris?
Yes, sir. Inspector Morris. November 24th of 2018, about 4 o'clock in the afternoon, I was on Thompson Lane. Had to make an abrupt stop. The vehicle in front of me did the same thing. There was a vehicle just stopped right in the middle of the road, right basically in front of Krispy Kreme. Nobody got out of the car. The car was just sitting there. And finally people started blowing their horns. So the vehicle pulled around to the next street. At that time I saw there was American Music City cab number 66. I noticed that a hubcap was missing. So when I drove on by, the cab actually pulled right in the middle of the street again on that street and stopped. So I came to the parking lot, pulled up beside him, identified myself, and told him to pull into a parking lot across the street. At that point, I was looking at the cab to see what the vehicle had issues for. Got out, identified myself again, actually also showed him my ID badge. Walked around the vehicle and saw numerous problems. So I came back, right before that I asked for his driver's permit. He had it stuck over his visor where it could not be seen. He started telling me that I had no authority to ask for it, that it was all right, that people could see it. So I told him, get out, let's walk around the vehicle, let me show you the other issues. Walked around and saw at least 7 issues, and I was explaining to him. He's very irate and the whole time. And I showed him the dent that looked like an accident on the front, and then showed him a broken antenna, and all of a sudden he was behind me. He grabbed the permit out of my hand, jumped in his car, and took off. I didn't follow him. I just sat there, started texting the incident to Director Fields and to call American Music City and their owner and advise them the same thing. He came back while I was doing that, driving around my vehicle, hollering, unintelligible to me, and then took off again. That's where we're at.
All right. Thank you, Mr. Morris. Mr. Ballard, did you want to speak on behalf of your client?
Yes, Your Honor. The committee, I'm just going to go ahead and just lead him, ask him some questions if that's okay.
That's fine.
Okay, Mr. Bashamo.
Oh, wait. Actually, do need to put both of you under oath. I apologize. I didn't do that with Mr. Morris. Bear with me for a second.
Maybe you could just ask him to ratify what he just said.
So both of you repeat after me, please. I swear or affirm
I swear.
that the testimony that I'm about to give is the truth, the whole truth, and nothing but the truth.
That all testimony,
Whole truth.
the whole truth I give, not the truth.
And Mr. Morris, do you ratify the testimony you just gave a moment ago?
Yes, sir, I do.
All right, you may proceed, Mr. Ballard.
Thank you. Okay, Mr. Wishamo, at the time that this incident occurred, were you on duty at all?
No,
Okay, had you been on duty at all that day?
yes,
That day you had been?
I'm not working that day. I'm not working that day.
Okay.
It's not duty.
The Krispy Kreme there, where Mr. Morris says that you were stopped. Where were you stopped?
I've been parking lot because it's the one he say like that, pulling in front of somebody car. There is no any car. I go in a Krispy to buy donut. I park in my car that place. Exactly the guy. I mean, I saw him cross street from the gas station before. When he saw me, he's coming the other side. But I've been parking lot. He's very far. I left it and then I go in there. He came when I park. He came the parking lot. Then he came the first time when he came that part inside I parking trying to get out. He came. He showed me the lights behind. I thought that time the Krispy Kreme security guy, and then he came out. He asked me permit. I take off my permit. I had my permit. He saw the permit. He's standing there like 20 minutes, and then he came back again. He round the car. Then he tell me step out the car. Okay, I said I step out the car. I'm scared. I used to have some kind of issue. Then come on, follow me. He say I follow him. He points a finger type scratch from my car because the baggage when he take him off there is some scratch, painting scratch. Then we went the other side. He came antenna, the bending antenna a little bit. I didn't see him. He came back. He tell me hubcaps. The hubcaps I was changing my tire, flat tire I got. I changing my tire, another one. The hubcaps I have in my car. I told him. Then he don't want to listen to me. Even that time, he used to have some problem.
Okay, so how long were you sitting there for?
They keeping me long hours.
At Krispy Kreme with Mr. Morris.
Yes.
How long was that interaction?
Just more than 45 minutes, 1 hour.
Okay, and he, Mr. Morris, said that you took your license out of his hand. How did that?
Oh no, it's not happening that one. But that time, everybody watching us. Mr. Marine, they opened the car. They searching me like people. They feel me like I did some wrong stuff or crime. Everybody watching. Some people they put a cell phone. They recording us. Then I didn't say anything. I told him I was inspecting this year because 4 months ago, an inspection place we have to inspect that one. I take there. I have stickers. I inspect my car. Then after that, when you go there, he had me like this. He just tell me, fix this until Friday. He say like this. I had him his hand. I mean, my permit. When I take my permit, immediately he say, you make mistake. What I did mistake.
Okay, so you thought he was handing you your permit back?
Yes, exactly. That one is. I'm not. I had him. I collaborate for him. I had him. I get out. I step out my car. I follow my car. Everything I did. What did he tell me to do? Then finally I had him, but I don't know. Somehow they brought me for this case. I don't understand.
Okay, and so the inspection that you were talking about, you had your vehicle inspected on 5/15/2018. Is that right?
Yes, sir.
Okay, and I'm sorry, I just got retained very recently on this. I didn't make any copies, but if the committee would like to see the inspection report. And on that report, it looks like everything passed inspection at the time other than the tires, but they were then approved, looks like a little later by Brown's Auto. So that was repaired. And Mr. Wishamo, the other items that Mr. Morris pointed out, have you repaired those since this incident?
Yes, everything is repaired. I used to have hubcaps. I put in hubcaps. The front one even scratching like finger a little bit style because we drive in all the place. Something when the road, something they hurt you. So that one all I take off everything because the company doesn't have. This is big stuff because of small things I take off. I replace that one too.
Okay, and since this incident, have you been able to drive for?
No, just immediate they call the company, take him out of business. They take me out of business.
Okay, and so yeah, it's been what 2 or 3 months since you've been driving. Okay, and as for the back up to the permit issue, it was in your where was it?
Yeah, because of permit we have this kind of a big permit. Our permit is not like an Uber small one, the big one. We put the people to visible. We put it like this, sun protector place. I put it this way is the type they have. I take him off. I give him. When I had him his hand, he tell me where you put it. I put it here to visible for the people. He just kind of advise him, but he tell me you're not supposed to put it that one. This is big things we have. We cannot put it front. Nighttime when they drink, they take it, they go. We cannot put it on the mirrors. So we have that one issue all the time, but this is the best place to visit, visible for the people. We put it in front of people.
Okay. And then at the time of this incident, you were actually supposed to be meeting someone?
Yes. Across the street, there is a actually Ethiopian restaurant, front Gojo, they call it. Thompson Lion and Crispy Kreme is here. The restaurant is there. I have a friend waiting me there, so I'm just trying to pick some kids. He's my friend. The kids has some small kids trying to pick some donuts. I went there. I'm not even working.
Okay, and then in his report, Mr. Morris says that that you came back to the parking lot and drove around his vehicle shouting something and then drove off.
No, actually, that's not right. That's the one I came to buy, that one. I mean, to get the donut. I don't even get the donut. I go around, then I left them.
So
Just
when you went around, it was just because of the parking lot?
The parking lot. That's not way. This is, I came out this way, and then I go on that one. I didn't do anything. I don't have any against him.
Okay. Members of the committee, I think that's our proof at this time. I don't have any further questions. I would just like to point out that he has basically been not working since this for 2 months. So I think any probation or suspension at this point has been taken care of. He said that he has fixed any of the issues. Perhaps maybe if there is some type of remedy, it's just having the vehicle inspected at the proper inspection place, as it was done back in May of last year, and confirm that the vehicle is in good condition, as Mr. Rashamo says, and allow him to continue driving.
Mr. Morris, do you have any rebuttal?
The only rebuttal, sir, is the parking lot is actually across the street that we were in from Krispy Kreme. I was there probably no more than, with him, 10 minutes at the most, the very most. But other than that, the report stands for itself.
So, Mr. Wakama, if I understand correctly, when American Music City found out about this incident, they suspended you?
Yes, sir.
Is it Wakamo or Washamo?
Wachamo.
Wachamo.
Mr. Washamo, do you drive cab 66 for American Music City?
Yes,
sir. And Mr. Ballard, right?
Yes, sir.
Why would we consider probation when your client says he didn't do any of these offensive things that are reported by Mr. Morris?
Just in the event that...
we decide to believe him instead of Mr. Washamo?
Yes, sir.
Mr. Washamo, you say the events that Mr. Morris has related to us, that you didn't do those things?
Yes. I didn't do
anything. Didn't drive around his vehicle? Didn't drive off and then come back and drive around his vehicle?
No.
You just drove around Krispy Kreme?
Just that one. I'm not going to be...
Can I ask a question?
Okay.
You just drove around Krispy Kreme and went across the street to your friend in the other parking lot?
Yes.
Didn't leave, come back and circle his vehicle?
No.
Shouting at him?
No, not shouting.
Didn't stop in the middle of the road at all?
Middle of the road? No. We go on one two-way, only 2 lines they have. One line he going right line, one line he going straight. I'm in right line. I get in inside when I get are parking over there.
And you were not disrespectful to Mr. Morris.
No, sir.
And you said you did notice that he had some sort of badge or law enforcement thing, right?
I know, but just trying to explain to him.
No. You said during your testimony that Mr. Morris had a badge or some sort of a law enforcement thing you saw.
Yeah, kind of, yeah.
Okay.
Repeatedly. I mean, like,
Yes,
I
sir.
just want to speak to him.
Mr. Washamo?
Yes, sir.
Had you seen Mr. Morris prior to that night? Had you ever had a meeting with him before?
I know him.
So you knew who he was at that moment in the parking lot. You knew he was an inspector for the Transportation License Commission, correct?
Yes, I know him.
Okay, I just want to
Yes.
just want to clarify because
Yes, I know
the
him.
reason I know is I've met with them together multiple times, so I knew that existed.
Thank you, Mr. Gill.
Yeah.
Yep.
Sorry, I was afraid I misunderstood.
In your encounter with Mr. Morris, did you get irritated? Did you get irritated?
No, sir.
Did you raise your voice with him?
No, sir.
Looked like Mr. Morris wanted to say something.
One of the things, sir, is that at no time did I have a badge on. The only thing I have is my ID of my shirt.
Yeah, I was going to say something like that.
Be sure I clarify that.
And let me, if I may, and again, I know it's late, and I know you've got 1 minute. I was not aware that he had been suspended from the company from all work until the day before yesterday. So we reported to the company that we had some problems. The company then apparently took their action to suspend him. It strikes me that period of time, and we can verify whether he was on service or not. If he hasn't worked since the November date at their request, not ours, it strikes me that is a fair punishment, maybe even more punishment. But the idea of some additional probation on the other end of it, no more punishment, no more suspension of service, but some probation on the other side just to make sure there's no other issues. Again, that would be your call. I haven't discussed that with the inspector, but I was not familiar with the fact that he had. There have been some. It's not in recent history. We've certainly had our share of conversations, but not in the last year and a half, something like that.
What would be the motion regarding finding that he has violated some? What is there a provision, or do we just find in general he's violated the spirit of the permit?
There is a display of permit 6.72170 and 6.72170, and it specifically states the driver to whom a permit is issued under this article shall have affixed to the interior of the vehicle for hire in full view of the passengers at all times the permit issued. So it does not specifically say where it has to be.
But what about the hostility, the lack of cooperation with the inspector, with Inspector Morris? That offends me more than anything, that his conduct towards Mr. Morris.
I guess I didn't realize that he knew who Mr. Morris was at the time, so that's even.
Yeah. If I may, I think from talking to Mr. Washamo, it seems like it's the middle of the day, stopped at Krispy Kreme, has a lunch across the street, it's taking a while, people taking pictures and videos of their phone. I mean, I think in any situation like that, any person is going to get a little anxious. Obviously, I wasn't there, but I think that is part of what Mr. Washamo was saying earlier.
I'm sorry, but Mr. Shama's telling me that he didn't do any of this. So, come on. Either he drove away and then came back and drove around Mr. Morris's vehicle shouting at him, or he didn't.
No, that one, come and shout it out. That's totally, he knows. I don't have any problem for that one to do it because already I have him to go that way. People waiting me even.
Mr. McNally, in response to your request, the only thing we've been able to find would require that there be a passenger present that would observe this behavior. So there's no just general conduct unbecoming or abusive language toward the actual inspector.
Well, Inspector Morris, I'm sorry. There ought to be something in there where they are under a duty to comply with your request, very much like drivers of vehicles are when the police stop them and ask for identification, registration, insurance, or to take a breath of blood alcohol. It just floors me that a cab driver could blatantly refuse to cooperate with you when you make a stop and there's a concern for the public safety. I make a motion to find that there's been a violation of 6.72.170 for failure to display the driver permit in the proper manner.
You can find violations of any vehicle condition issues that Mr. Morris identified as well.
I'll add to that motion that there were, as reported by Inspector Morris, that there were several vehicle violations from the antenna to damage to the vehicle. Hubcap, well, it's listed here 1 through 7 of the report dated December 1st, 2018. Hubcaps missing, large sections of paint missing on the rear bumper showing green, rear tail light broken, right side passenger door molding needing repair to replace, right side antenna broken, front end appeared to have been an accident, needed to be repaired, left side antenna completely broken and missing, leaving a hole in the fender.
And there's nothing in the provision, I know I'm breaking Robert's rules here because we have a pending motion, but there's nothing in our provisions regarding cooperating with an inspector or anything.
No.
I'm looking through the rules right now, but I haven't even found anything in the rules that speaks to that. So, again, it looks like we found a new addition.
We have a few revisions for this as well.
If you would like, as part of your motion, you could add that we look into adding a rule, or you could add a rule actually.
Next month, we could have a
Next
public
month, you could have a public hearing and make a rule that they have to be courteous to the inspectors. That's much quicker than amending the code.
Yeah, I'd rather leave the motion regarding a violation against Mr. Washama as it is without complicating.
Second. All those in favor?
Aye.
Motion passes.
The date you said that he stopped working for was put on probation with American Music City?
Yes.
What date? November 24th?
He write it down.
December,
He called the dispatch, take him out. That is here, take him out of service, he say.
I think it was the same day, 11/24, or very shortly thereafter. Was it the day?
Yeah,
of?
that day, and then, that day, since that day, he was telling me you don't have to.
I make a motion.
Then after that,
I'm making this motion more lenient than I would, only based on what Mr. Fields had just said a moment ago. But I'm going to make a motion that Mr. Washama be suspended from operating a cab for a period of 4 months, given credit for the 2 months that he already has been not driving, and then placed on probation for 1 year.
All those in favor?
Aye.
All those opposed? Motion passes.
This is the second.
Can I
No.
talk one time? I used to have this issue with the last year there wasn't brought me here. No. Last year I used to have this issue. My car is there. My car is here. I take an inspection place over there. My car was being 3 company. They take me out of the 2 company. I have me here. I went to transportation license and commission office to inspect my car. Inside there, they did not inspect the car. I have a meeting for this one. I'm complaining about the issue every year. November, the last November, and then the November. they took my car out of service this year, last year. I went there, they inspected by themselves in the office. Because the car, they tell me, this car doesn't have, the color is different. They don't have, we have a code number here. I have a code, everything, the cars I painted by professional painting.
If you need to go, I'll look at this stuff.
Econo. I painted this one, the code number is right, everything is right. So finally they decide not to come there. The appointment I'm making to come here and then to explain about him. I have a problem with this inspector. 2 times they take it out of business, the car. I bought it $10,000. They say they take the sticker, they take them out, another I buy. I put it another company. I went to another company which is Music City company. Then this car is here. It says inside of Transportation Licensing Commission. This is inside. They refuse me to inspect my car. Then they say this is not the color, the right color. 20, 40 cars, they are different cars. They used to have them, wrong number, no wrong number.
Mr. Washimo, I think I see where you're going here. If you have a complaint you wish to lodge, you need to do it formally, not informally like this.
Yeah, I know, but what I'm saying is just to know it, but it's not about that one. I did not say anything for him against. He came to, this is not right things. To know it, this is, you have to know it, this is on purpose. They do it to me.
Mr. Washimo.
Yeah, but it's not, I'm not doing it like, not the first time. This is the second time they have. He knows, he inspected the car. I was inspecting one time, the second time. Okay. I'm sorry. So, I mean, this is, I have an evidence and everything. We cannot do anything. I did not say him anything. I went, I'm not duty, I'm not working. That time he came. Inspection I did 3 years by different people. 2 times, 1 time by Billfield, 1 time by Brandon, because they refused it. This year I did it by new inspection, but he didn't find me anywhere. He found me that place, out of service. I'm not even working that time. He came, he did this one, because I did not say him anything. We know him. 125 drivers, petition he signed. I used to working for, actually they nominate me to help them, cab drivers association. I'm not working no more. I'm not even, I left because I'm become victims addressing the driver issue for transportation licensing. I'm not, I'm the only one person, I'm not working. But it just, it's not fairly they came this way. I did not talk to him, I did not say him anything. This honestly, I'm telling you, this is the truth. He came, antenna, the $5 issue, the hubcaps I say that's $5 issue. The cars, 3 months, 4 months, they take me out of service. Almost November until today. I'm not going to be against him. I'm not going to talk to him. He made it this way. The truth is this one.
Mr. Washimo, there's already been a motion. There's already been a ruling. I appreciate your statement. I've let you speak, but we've made our ruling.
Yeah, I mean, no, it's okay. I'll accept, but a driver has rights. I mean, try to listen to them. Try to listen us, because there is a big issue with them. They stopped him 2 years not to inspect, because driver, they used to have an issue with the inspector.
I understand.
Another
And
inspector they hired.
I told you if you have a specific complaint you want to bring, you can file a formal complaint with Mr. Fields.
Yeah, I mean, so what's the decision?
Thank you.
Motion to adjourn.
All those in favor?
Aye.
Motion passes.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.